There will be some difficulty.
Then tomorrow, my lord. Filed on long back, my lord, on 13/2, my lord. It has not been listed.
Thursday, second.
My lord. Highly obliged.
Lordship, I was a similar player. I have filed the motion, Lordship, last 20th of February, Lordship, till that. Nothing.
My lord, another prayer for listing of an admission, my lord, on next week, any date as per convenience of my lord.
Next week, practically, there's just 2 working days.
My lord, then.
Yeah.
Yeah.
14th.
My lord.
May I please, I beg to mention for listing of a motion matter, my lord, on Friday, my lord. The urgency is it, my lord, the last date is 13th March, my lord. It is regarding, my lord, appointment of the assistant professor. Advertisement was issued on 21 February, my lord.
We'll have it on 9th March.
9th March, my lord.
May I please,
Obliged,
Your
my
Lordship, I beg to mention a contempt case, Your Lordship, or orders, Your Lordship. Any date after 14th, Your Lordship.
20.
Bless Your Lordship.
Wait, please, my lord. My lord, I beg to mention for listing of an review petition, my lord, for Friday, my lord, if it is not inconvenient to my lord.
On review of my order.
Yes, my lord's order. The order was passed on 6th of February, my lord. So a direction was specifically issued by your lordship to comply with within a period of 14 days, my lord. So we have reviewed this order, my lord. We have filed it today. So kindly it may come on 3rd of March, my lord.
Will be just listed. If it is filed today, then it will be difficult to have it on Friday.
Friday, my lord.
Okay, right.
3rd. I'm deeply obliged.
May I please, Your Lordship.
Lordship, I like to mention WTC E225/22 listing on 2nd March, Lordship.
Not 10.
Lordship, then 13. 13 March.
15.
15.
Lordship, I beg to mention 2 items for listing. One is writ petition 2509 and
20 March.
Lordship, 15th of March would have been obliged.
May I please, Your Lordship. Lordship, I prefer listing of WBC 3694 of 21, Lordship. Lordship, on any date and convenient to your Lordship, it may be taken up.
17.
Obliged, Lordship.
Of supplementary motion.
Item 24, Lordship, can take up staff time, Lordship. With the AG is on the way, Lordship.
Who?
Advocate General, Lordship, will appear in item 24. Just after some time, Lordship. He is on the way, Lord. All of this, time being.
My lord.
Just after for a time being, Lordship.
25.
May I please? My lord, the background of the writ petition is there were 2 schools, my lord. Both were in the madrasas. One was a title madrasa, one other was a senior madrasa. Now both got provincialized in 2013. I was in the title madrasa as a principal and I got provincialized as a principal of that because it's a higher secondary level. The other school also got provincialized. These both schools, my lord, in terms of the decision of the government, got converted to high schools, normal schools. It is called Jamirahat High School A and Jamirahat High School B, same campus. So in terms of the government decision, both the schools were amalgamated. Now in Jamirahat B, my lord, there is an assistant teacher holding the charge of headmaster, whereas I am the regular headmaster. Schools were amalgamated, no issue, my lord. Jamirahat A, School A was made the base school. The respondent number 6 filed a writ petition saying that it should be the Jamirahat High School B, which should be the high school, which should be the base school. Fine, government agreed to that. Done. Now, while agreeing to that, my lord, projecting him as the headmaster, he has been given the power of DDO. Whereas, my lord, I am the regular headmaster and he is just an in charge. If he gets it tomorrow, fine, my lord. But how can a regular be replaced by a ad hoc? My lord, if lordship comes to the page 14, my lord.
Yes.
My lord, in persons of government letter number whereby so and so have been created for Hailakandi district under the provisions of the Act 11 as amended, the above mentioned posts are hereby allotted to Jamirahat Title Madrasa with effect from 1/1/2013, which was recognized on so and so. Lordship comes down to the names of the persons. 1, That's the petitioner Mohammed Morbur Borbia, principal. Then, my lord, government had taken a decision on 3/8/2021, which my lord would find at page 16. This is called Shiksha Setra, a scheme for amalgamation and merger of different schools. Now, here relevant would be, my lord, page 18, clause 15, down below, my lord. Further, the following shall be conditions, including service condition and employees shall apply after merger. The schools having good infrastructure facilities together with amiable academic atmosphere and proper road connectivity in comparison to the other school shall be the base school, and other school shall be merged with that base school. The senior most principal headmaster shall be the principal headmaster of the school after merger. My lord has got it. Now what had happened, my lord? If your lordship can come to page 21, this is the statement of amalgamation. Both the schools, my lord would say name of the schools to be amalgamated: Jamirahat High School A and Jamirahat High School B. No, Jamira. My lord would come to the next page, 22, my lord. This is the statement of the persons working therein. My lord would see the top one, in position, cadre principal, Morbur Borbian. My lord has got it. He is the petitioner. My lord comes to school 2 on the left-hand side. Thereafter, third name, in position 80, Hibzur Rahman Laskar. Third name, my lord, after school 2. One is Amir Hussain, Nasiruddin Laskar, and Hibzur Rahman Laskar. My lord has got it. He is the respondent number 6. He is an assistant teacher. Now, my lord would come to page 23, the amalgamation order. My lord would find Jamirahat B and Jamirahat A school amalgamated. I am only on condition number 3, my lord. The post held by the employees, including vacant posts of the amalgamated school, shall be the posts and employees of the base new school. So I was a principal. Naturally, in a high school, I'll become a headmaster. So, my lord, I'll be there. Now,
You were the principal in
Jamirahat A school, my lord.
this school.
A school, my lord. So, my lord, I was then, my lord, continued as the DDO also. That, my lord, would find at page 24. Serial number 10, my lord. Copy 2. Serial number 10. The Treasury Officer, Hailakandi Treasury, the headmaster of Jamira High School A will be the DDO for disbursing salaries of all employees mentioned above. Because I was the only regular one then. Then, my lord, the respondent number 6 comes up before this honorable court, saying that his school should be the base school. That's, my lord, WPC 3972/2022. Page 26 is the order, 15/6/22. My lord may have page 27, the second paragraph from bottom, my lord. After hearing the learned counsel for the parties and considering the entire aspect of the matter, this writ petition is disposed of. The motion stage itself, directing the petitioner to prefer an appeal under clause 19 of the office memorandum dated so and so before the secretary to the government of Assam in the Secretary Education Department on or before so and so, along with a certified copy of this order and the copy of the writ petition, including annexures appended thereto, obtaining necessary acknowledgement from the said authorities in the regard. So, my lord, they were directed to consider that appeal. Now, on consideration of the appeal, page 29 is a report from the IS. My lord, here he projects the B school to be the best. The headmaster therein he shows it to be a present headmaster. Then, my lord, I make a representation at page 31, my lord. 11/11/2022. My lord, relevant would be page 33, paragraph 4, my lord. That be thus, as it may, clause 15 of the so and so provides inter alia that the senior most principal headmaster shall be the principal headmaster of the school after merger. In the instant case, I am the regular headmaster of Jamira High School A, and on the other hand, in Jamira High School B, there is no regular headmaster and one assistant teacher is holding the charge of headmaster from June 2022. After issuing the amalgamation order, in any circumstances, I am entitled to be the headmaster of the school after merger, as I am the only regular headmaster. Now, my lord, they pass a fresh order at page 34. in pursuance to the order of this honorable court, my lord would only see the column wherein the names have been given. Base school now is Jamira High School B, and Jamira High School A amalgamates with Jamira High School B. Earlier it was the other way around. But my lord, clause 3 here. The post held by the employees, including vacant posts of the amalgamated school, shall be the post employees of the base new school. The details of the post so and so, Annexure B was not given. But my lord, here also, as in clause 8 in the earlier order, the post will continue. So my lord, I am the regular headmaster. I should continue. Now my lord would see what they have done at page 37. My lord. Clause 10, my lord.
Page
37. My lord. It's a part of that letter. 37, clause 10. The treasury officer, Hailakandi Treasury. My lord has got it. The headmaster of Jamira High School B will be the DDO for disbursing salary of all the employees mentioned above. This is total non-application of mine because there is no headmaster in school B. I am the regular headmaster in school A. My post gets carried forward to the amalgamated school. I continue as the headmaster, principal or the headmaster. But my lord, total non-application of mine here. Now the respondent number 6 has been given that responsibility. This is what I am agreeing with. Base school, merger, no issue, madam. But even if you merger as per your scheme, it will be, my lord, the post senior most who is there. I'm the regular. So there is no comparison between me and the respondent number 6, my lord. Because he's only there on in-charge basis. My lord, I'm praying for an intervention of your lordship with this regard to this clause, my lord.
this. There's no order issued.
No order issue, only like this.
Yes.
I have to take instruction in this case, lordships.
What is it?
I have to take the instruction, lordships, regarding the issuance of this order, lordships.
Whether any order has been issued.
That I have to take instruction.
No further orders have been issued, my lord.
Come on Friday, lordships. I'll get the instruction in the meantime, lordships.
My lord, I am appearing for the respondent of 6, my lord. My lord, in this, my lord, he is the principal, my lord, of the title Madrasa, my lord, and not as a regular headmaster of the said school, my lord. After conversion, my lord, from high school, my lord, from title Madrasa to the high school, my lord, his post has not been converted, my lord. He remains as a principal, my lord. And as in a high school, my lord, there is no post of principal post, my lord. And principal post is a higher cadre than, my lord, headmaster post, my lord. So in this way, my lord, he cannot be the headmaster of the ML.
That we'll see.
Yes, lordships.
Lordship would have that order, my lord. My friend's contention that I was a principal, then the school got converted to a regular school. My lord will have 2B, my lord.
Page.
The first one, my lord, the first page.
Ah.
Roman 2B, my lord.
Ah.
The existing staff of both teaching and non-teaching of the madrasa educational institutions, which were governed by under the rules mentioned under clause 1 above, shall be governed under the Assam Secondary Education Provincialized Service Rules 2018 with effect from the date of commencement of this notification, and their condition of services shall continue without any change in their status and pay. So, my lord, principal, I'll be designated as a headmaster, but I'll be getting the scale and pay of principal all along. And that's what I'm getting today also.
My lord, even he is not qualified for the post of headmaster, my lord.
That's a different issue altogether.
As the, my lord, as per the service rule, my lord, service rule 2018, my lord, it is applicable, my lord, as it is converted to the secondary school, my lord. So as per this, my lord,
Anyway, let Mr. Chifti get the instruction.
my lord, they may not be granted, my lord.
Let it not be on Friday, Tuesday. Why not we have it on, even if it is a hearing day?
9th.
On 9th.
No.
Whenever it's convenient, your lordship.
Okay.
Then lordship,
9th or 10th.
14th. 9th and 10th is lordship packed up, lordship.
14,
Whenever it's convenient, your lordship.
14 will be
14.
14 will be best, lordship.
on 14, my lord,
Yeah,
yes, my lord, on 9th, I have some problem, my lord.
but you can Ireland. Can you hear me? Mr. S&P Chifti, the responding counsel.
For secondary education.
Secondary.
Education shall receive instructions. This the matter on
14th.
14th.
14th of
The interim orders will be continued, consider on that day. My lord is not issuing a notice.
No, I'm not issuing.
Yes.
Lord will say status quo as on today will be maintained, my lord. Whatever it's
In the meantime, what is our direct implementation of the-
with regard to the post of DDO.
Only lordship extra copies may.
Yeah. I'll give it. I'll supply. My lord need not write, my lord, I'll supply it. I'll supply it.
Which
So did you get a copy?
post of DDO in Jamira,
Jamira High School, my lord.
in Jamira.
Jamira High School. No, yeah, Jamira High School. will be available, no?
That's all, no? Jamira High School.
Jamira High School. my lord.
Oh, AB.
Yes, amalgamate was a key. It will be Jamira High School B, my lord.
Jamira High School.
B. Much obliged.
Look, here, my lord, last occasion, I was directed to file affidavit. My lord, I think affidavit is not required, my lord, because my lord, order which is impugned, that has already been recalled, my lord.
Right.
Huh? So,
I don't understand what submissions they are making.
Right.
There was an interim order passed by my lord, staying that order of transfer. In consequence thereof, in terms of that order, they have done it. That order goes, this order will also go, my lord.
Which
It's-
order?
My lord, that interim order passed by my lord. There is an interim order passed by your lordship.
police, my lord. If required.
My lord
will
will see the order dated 6/1/23, my lord, in this in the writ petition.
Yes.
My lord would see the last paragraph, there, the order of the transfer was stayed, my lord. My lord has got it. Now, my lord will see the order produced by my friend. In compliance of the Honorable Gauhati High Court's interim order dated 6/1/23 passed in so and so in pursuance of the order issued so and so, Abdullah is hereby reverted back to his earlier place of posting with effect against the existing post, and Tajuddin Senior is directed to temporarily take over charge so and so until further orders. So, my lord, this is in pursuance to compliance of your lordship's interim directions. I can't be kept hanging, my lord. There has to be a compliance, so I was sent back. But that will not mean that the order of transfer was withdrawn, my lord. There is no order withdrawing the order of transfer, my lord. This is only in compliance of 6/1/23.
If required, lordship, we will revisit the order, my lord. We will pass a fresh order. Otherwise, we will make an correction.
My lord, whenever there is an interim order passed by my lord, how can they go beyond that?
You take instructions properly.
No, my lord, this interim order, my lord, if this is so, my lord will vacate the interim order today, my lord. And let them take for fresh decision. The interim order, my lord, if there is no case, the writ petition does not survive, my lord will recall the interim order. Let them then act, my lord.
Yes, where?
My lord, if the interim order is recalled, my lord, then my lord, obviously this writ petition will become, my lord, infructuous, and in the,
Where is the impugned order?
my lord, the impugned transfer order, my lord, may be pleased to find. My lord, is at page 128. No, my lord, it is at page.
Interim order is here, order to withdraw. Teaching issue.
My lord, is at page 128.
128.
128, annexure 20. My lord. I am, my lord, aggrieved by the second part. In the interest of public service, so and so Barbhuya, principal of Diet Kachar Udarman, is hereby transferred and posted at Diet Hailakandi in the same capacity against the existing vacant post. Dr. So and so, this was under challenge, my lord. This honorable court was pleased to stay this order, and pursuant to the stay, my lord, this Abdul Noor Barbhuya was again reverted back, my lord, to his original place of posting at Diet Kachar, my lord. It is a, my lord, one kind of, my lord, that due to the interim order, my lord, they have interfered with this order, my lord, and he has been reverted back.
If that be so, let him withdraw the writ petition, my lord. If that is the understanding of the petitioner and the department, that will be the end of the matter.
My lord, with my limited understanding, my lord, I am submitting, my lord. And if, my lord, the authorities is going to revisit this order, my lord, then let them revisit, my lord, and this petition can be kept pending till the revisit is done, my lord.
Abdul Nur.
Barbhuya, yes, my lord.
You're for risk under?
I'm for the, my lord, I'm for the
Nur Barbhuya.
Abdul Nur Barbhuya. Tajuddin is the
Petitioner.
He's not there. He was holding that post on in-charge basis.
My lord has already heard this matter, my lord, and today actually was for the affidavit is required to be filed by the respondents. Now they have said, my lord, that this order has been interfered with. So, my lord, they will take a fresh decision on the order, my lord.
No, you'll have to explain.
Yes, yes, my
My
lord.
lord, I'm explaining to your lordship, my lord, what had happened. I was involved. My lord sees the order. There was a transfer order. My lord was pleased to stay it. Now, where will I go, my lord? I'll be hanging.
1 minute. Tajuddin last class.
My lord will come to page 34 of the, the order dated 6/1/23, paragraph 21 thereof. Paragraph 21, my lord has got it.
Yes.
As such, the impugn order of transfer of respondent number 6 as principal of diet in terms of notification dated issued by the state government and Department of School Education shall remain suspended until further order of this court.
Respondent number 6.
6. That is me, my lord. Abdul Nur Barbhuya.
So they've withdrawn this order.
No, they have not. What they have done is, because the order was suspended, my lord will come in compliance of the Honorable Guwahati High Court's interim order, dated so and so, passed in so and in pursuance of issued order, is hereby reverted back to his earlier place of posting against existing vacant post, and so is directed to temporarily take over charge, until further orders. That means, my lord, till the time the interim order subsists. And they want, by this way or the other, the matter should not be heard. My lord was clear on the order was clear that if the matter is not heard, my lord will take up the interim. First and foremost, my lord, he is an in-charge principal. He has got no right. How can he interfere with my regular order of transfer, my lord? I'm a regular incumbent in the post of principal. His only case is that these posts are to be filled up by promotion. You cannot bring him on transfer. My lord, the rules itself says that the post of senior lecturer, which he is to be filled up from promotion by way of from lecturer, and the post of principal from senior lecturer. So, my lord, he was promoted as senior lecturer in a different institution, and he came on transfer to this institution. If there is an exception for him in the rule, he can show. I have nothing to say, my lord. Otherwise, he also is a beneficiary of a transfer. How can he, after having availed that benefit, assail that matter?
So he's the senior most lecturer.
He's a senior lecturer.
Senior lecturer, my lord. Now,
Person senior to him.
yes, my lord, with my
All state cadre, my lord.
my lord, with the objection raised by my respected senior friend, my lord, regarding the locus and the what right I have been, my lord, my right has been, how it is infringed. I will satisfy, my lord, and that question was raised on the very first day, my lord.
Let him satisfy that one
Yes,
first.
yes, why not? My lord, the issue is that this order which had been placed, and my lord, my respected senior friend has said that by this way or that way we are delaying. It is not the case, my lord. It is the case that my lordship was pleased to direct the respondents to file an affidavit on the contention raised in my writ petition, my lord. Now, till date, my lord, they are
Nair,
my lord.
you want this impugned order to stand, correct?
My lord.
You want this impugned order?
I want the interim order to go, my lord. If the interim order goes, the order will automatically revive. My lord.
You want this order to be revived
Lordship.
by vacating the interim,
Lordship.
because you are saying you are you are regular,
Regular. Principal.
principal. He's not a regular.
No, he's in charge. And I can show from the order, my lord.
Yes,
114, my lord.
yes, my lord, I am the in charge, my lord. I am not disputing that, my lord. Now, how my right has
To
been.
page 114, my lord. My lord would come to 114. In the interest of public service, Mohammad Tajuddin Loska, senior lecturer, that is the petitioner, is hereby transferred and subsequently posted as senior lecturer at DIT Hailakandi with effect from the date of taking over charge against the vacant post. So, my lord, he is also a incumbent. The post of senior lecturer is filled up by promotion, similar as that of principal. So, how could this order be done, my lord? Then, my lord, on his posting, he was allowed to take over charge of the post of, my lord will see that order. Next one, consequent upon joining so-and-so as senior lecturer so-and-so, along with financial powers under so-and-so, dated so-and-so without statutory power with effect from the date of taking over charge until further order or till full-fledged principal is posted. Now, a full-fledged principal has come. He'll have to make waiver. And this order, my lord, he is being by doing this or that. I had filed this IA way back now. I had filed it, my lord, sometime in
This way or that way, my lord. It is the procedure of the law, my lord. I have filed a reply.
January, my lord, I had filed this, January middle. Till date 2263, double time it has come, my lord. But I was not pressing on 2263 because I wanted it to be on merits, my lord. Now, my last 3 occasions, my lord will remember, we heard the matter. And then, my lord, the department says we will file an affidavit. Then they come up with another story. My lord, this is not called for, my lord. When an applicant is before my lord, either this way or that way, the parties should agree to a disposal.
Yes, what do you say?
Well, here, my lord, this order may be wrongly stated in compliance, but we will revisit the order, my lord, and recall the impugn order, my lord.
Transfer order.
Transfer
My lord,
order.
we'll record that statement. That
Well-
he's not, there's an impugn order of transfer, the government is going to withdraw. Finish, brother. That'll do. And the petition can be disposed of on that.
What is it?
They say that the impugn order
The
of
impugn
transfer
order,
will be withdrawn by them. That I'll not be transferred. That is what he's
Well-
trying to put, my lord. Can he make that submission, my lord?
my lord, we will revisit the order, my lord, as per this
What
order.
revisit, my lord?
As
How
per-
can they revisit when the interim order is subsisting before your lordship?
Now, everything has been by this order, you have.
Let them withdraw that order, my lord. Because once an order is passed by the government, my lord stated, I will say they have done it in the proper manner, that they have complied with the directions of this honorable court. Saying there is a stay, so you go back. But that does not mean that the original order is gone, my lord. The original order is sub judice before your lordship. They can't touch it, my lord.
Yes.
My lord, will file, pass a fresh order, my lord. Recalling
Can't, my lord.
the transfer order, my lord. Let the respondent be remain in his post, my lord.
What is the submission my friend is making, my lord? I don't understand. He is not the authority. That they will recall the transfer, then my lord will record that and dispose of the writ petition. My lord, I'll come back. I'll challenge that order of recalling, my lord. Or my friend can take his instructions, come back to your lordship tomorrow.
Yes,
My lord.
that will be better.
I'll take.
Yes, you take instructions.
My lord.
Tomorrow.
my lord.
Not tomorrow, on Thursday.
Thursday, man. Tomorrow is Wednesday. Thursday. Thursday.
Yes, we are. Thursday.
My lord, my lord.
Bhuya is very happy.
No, my lord. I am learning from my senior friend, my lord. It is not a question of happy, my lord.
You can hire, then it's near confusion, what you have time, you will say.
How you know, ulta pulta submission diyo. So the interim order can withdraw করছে।
Mr.
I'm PK Borman,
P.K. Bora, then the standing council,
elementary education.
elementary education. Place for some time to receive instructions. Praise the Lord. This the matter again on 2nd March.
Much obliged.
Do something about this.
My lord.
May I please your lordship?
Yes.
Your lordship, my senior has some personal difficulty today, as there are some Parhad matters in court number 1, your lordship. Let the matter may come up some other day, your lordship.
On 2nd of March.
Which is near?
Kane Chaudhary, sir.
This is the pattern matter, lordship, 2nd of March, lordship.
2nd of March, there will be some, you are appealing for petitioner.
I am for petition.
Your good time, please.
Didale, lordship.
T. Dolly.
Lordship.
T. Dolly, Learned Council. On request made on behalf of Mr. K. N. Chaudhary, Learned Senior Counsel, for this phone number.
4.
Four, your lordship.
There's some difficulty now. 21st March,
My lord.
because I think next 2 weeks I'm not.
Yes, my lord.
Yes, your lordship. Deeply obliged, your lordship.
Partner.
My lord, kindly timing for the past.
Who said?
the timing, my lord. Take away is held up in another court, my lord. Already our submission.
Oh.
Is he coming?
Yes, my lord.
Otherwise we can. Okay.
4, 5, and 6.
May I please, your lordship? Your lordship, Mr. Brigogo is supposed to appear for this matter. Your lordship, he's on legs in court 1. Kindly pass over the matter for the time being.
Let's, my lord, I'll continue or
Let them come first.
Right, your lordship.
My lord, in this case, the petitioner has challenged the B.Ed degree obtained by the private respondent, my lord. And during the pendency of this writ petition, as per the honorable court's interim order, the speaking order has been passed at page 46.
Page 46.
Yes, my lord.
Where's page 46?
On the continuous page, my lord, internal page. It is the affidavit filed by the respondent, private respondent 6.
Yes.
Yes, my lord. And challenging this speaking order, we have filed another writ petition, which is coming tomorrow at item number 13 before your lordship. So this matter may be taken along with tomorrow's matter, my lord, item number 13.
What is that item number?
Writ petition number 1026 of 2013. Tomorrow.
Yes, your good name, please.
And Sharma.
On request made by N. Sharma, the council for the people. List this matter along with WBC number
1026
1026 of
2013
2023
23. Yes.
of 2023
Which is fixed tomorrow, my lord, item number 13.
on the first.
Bless you.
My lord, in the morning, lordship,
Yes, somebody was mentioning.
lordship, because of illness. Yes, he telephonically informed me, lordship.
Who?
That is Mahanta has informed me,
Monta informed you?
lordship. Let it be on the 9th, lordship.
Third K. Mazumdar, Learned Council for the petition. On request.
My name may be, but as per his prayer, lordship, I pray.
K. Mazumdar, Learned Council for.
My lord, I seek for adjournment today, my lord. In this matter, I appear on behalf of the respondent number 1 and 3, the Council of Architecture, my lord. Here the English Council, Mr. Mohan, my lord, in this course today, my lord. May I prefer date, my lord, on 9th of March, my lord.
On request made on behalf of Mr. P. Mahadan and the council for respondents 1, 2, 3.
1 and 3, my lord.
2 I am appearing. my lord.
1 and 3. This is the matter again on 9th of March.
Highly obliged, my lord.
9. My lord, in this case, lordship, Assam Science and Technology University Lordship Council
need for lordship because. What is wrong today? Nobody is here.
Mr. Bhattakur was appearing earlier. Namda Hagen.
কোন আছে?
Big we know Bhattakur. Is a very university, Assam Science and Technology University.
We'll adjourn the matter. But they are adjourned and then come. None of this.
It may come on.
This matter again on 16th March.
Lordship will.
Ten lordships, this case was lordship R. Muzumdar, he was handling this case lordships. So he has some difficulty. Lordship may kindly take it up on 14th or 15th lordships. So we have filed our affidavit. I have seen that he has filed his affidavit also. Everything is clear.
I could not follow submission of my friend lordship.
Rajesh Muzumdar করি ছিল না Rajesh Muzumdar তার আগে সলভিং নেগেটিভ করতে অলপমান প্রবলেম হচ্ছে
Okay. But Mr. F.Z. Majumdar, then the conflict on request met on behalf of Mr. R. Majumdar. Then it's standing council,
secondary.
secondary education. List the matter again on
15.
No, lordship, 15, it is, if possible, first week of the March.
first week of
First
March.
week holiday is all holidays are there, no? First week to 8 week first week.
First week, no?
First week is
10th March,
Yes, lordship, 10th March.
no, not 10th, I mean 14th, 14th.
yes.
March.
14th,
Yes,
14th.
right. Ready হয়েছিল
And lordship, it can be taken up for disposal on that day, lordship.
Yeah.
Yes, we have filed our affidavit. I have seen.
Obliged, lordship.
May it please your lordship. Lordship, here petitioner was appointed as additional science teacher in 1999. My lord, thereafter
The affidavit has come.
affidavit has not been.
Yes, Mushari.
Lordship, on the last occasion, the records were called for your lordship.
No, it is 11.
No,
It-
no.
11.
record so far.
It is 11.
Next week.
Nothing.
My lord, my only prayer, my lord, they have my.
You want sometime? But Mr. M. R. Pandakar, then on request made by Mr.
GP.
G.P. then
Elementary.
standing council elementary. 4 weeks time you want?
Yes.
4 weeks time is allowed to file contract. List after call.
My lord, a date may be fixed, my lord.
31st.
12, my lord. A record was called for and I think my friend has received, my lord. Here, my lord, petitioner was appointed on 1/5/1993 as assistant teacher in a 5-class high school, my lord. There is a high school from class 5 to class 10, 5-class high school. So he was appointed in ME section. For that, his post also approved for ME section, page 42, my lord.
Yes.
42, my lord, here is the approval by the IS, my lord. Middle section, serial number 5, my lord, Abdul Awal. That is the petitioner, assistant teacher, PU passed, date of joining 2/5/1993. Then, my lord, in the year 2013, all teachers have been provincialized under the 11 Act. He had left out. So he approached this court, but in the meantime, Act has gone, my lord. That is why the Honorable Court, by its order dated page 52, this is his second read petition. By this order, my lord, page 58. Kindly turn to page 58. My lord, middle para, since the said Act 2011 Act, my lord, got is page 58. My lord, since the said Act 2011 Act is no longer in force now, and the Act and the 2017 Act noted above has been brought into force, the Director of Secondary Education Assam shall now reconsider the case of the petitioner in terms of the provisions of said Act for provincialization of his service. So, my lord, after this order, page 62, my lord. That is the speaking order issued by the Director of Secondary Education in terms of the Honorable Court's order, directed the petitioner to apply a test before the District Scrutiny Committee under the 2017 Act for provincialization of it. Then, my lord, page 68. That is the report of District Scrutiny Committee, minutes. My lord, from below, second parameter. The committee also, Lordship got it?
Yes.
Also perused the speaking order issued by the Director Secondary Education Assam by memo number so and so dated 6/2/18, and wherein it was instructed to look into the case of Abdullah Wal, assistant teacher Namargaon High School, in the light of Assam Secondary Provincial Education of Teachers and the Organization of Educational Institute Act 2017. The applicant Abdullah Wal also fulfilled the required qualification by obtaining degree. In the meantime, in 2016, he also obtained the graduation also. So he was found eligible and his name was recommended. Page 70. In terms of the District Scrutiny Committee report, the Inspector of Schools submitted proposal, resubmission of proposal for provincialization of his service to the director. Then, my lord, nothing has been done. So the petitioner approached this court, page 72. In this court, the Honorable Court disposed of the matter with a direction to come to directed to pass a reason order. That is page 74, paragraph 7. My lord. Page 74. Lordship got it?
Yes.
Accordingly, the director of the directed to pass consequent reason order on the recommendation made in favor of the petitioner for provincialization of. Then, my lord, the speaking order, page 76, was passed in terms of this Honorable Court's order. Here, my lord, from below, second para, on the above facts and circumstances stated above, the matter of provincialization of service in respect of the petitioner cannot be considered as per section 423 of the Assam Education Provincialization of Service of Teachers and Reorganization of Educational Institutes Act 2017 is amended. So my case has not been considered. One ground saying that as per section 423, this section, now I can kindly come to face merit of this act. This section says a teacher must render at least 6 years continuous service as on 1/1/17. Petitioner was appointed in way back in 1993, my lord. So, my lord, section 4, that is page, my lord, page 114 of this act. 114, relevant page 115. Lordship, page 115. 114 is the section 4. Lordship got it? Teachers or tutors to be government servant. Now, my lord, section subsection 2 of section 4, the teachers and or tutors to be provincialized under this act. Now page 115, my lord, 3, Roman 3. Must have rendered at least 6 years continuous service as on 1/1/17 from the date of joining in the concerned venture educational institute. So, my lord, he joined long back in the year, joined on 1/5/1993. So, my lord, after this, we have again challenged this order by filing a writ petition, page 79. Yes. Here, my lord, by this order, Honorable Court issued a direction to the Secretary, Commissioner Secretary, to dispose of my appeal, because appeal was filed within a specific time, taking into account of section 7, my lord, where provides that 5 years time also been given to obtain educational and professional qualification to be a government servant. So in terms of this Honorable Court's order, they have issued the impugned order, case 89, my lord, is the relevant order dated 21/11/2022. 89 order, my lord. Page 89 is the vernacular. Well, page 89, paragraph 2, middle, my lord. Further, as reported, the state level scrutiny committee, lordship got it, found that the petitioner does not fulfill the eligibility criteria of educational qualification required for provincialization as per the Assam Provincialization Service so and so Act. Now, order, my lord, after careful consideration of the above and all other aspects, it is decided that the claim of the petitioner for setting aside the order passed by the Director Secondary Education dated so and so cannot be considered. So I have filed an appeal. That appeal also for setting aside the director's order, that has not been considered. So, my lord, here, my lord, petitioner is now, he has hardly 4 or 5 years left, my lord. He is going to be retired. Since 1993, he has been working. Under the 11 Act, he also deprived. In the meantime, he unfortunately Act has gone. So, my lord, this is the position, my lord.
Lordship, the records were called for on the last occasion.
এখন affidavit did, yeah. That will be better.
But you will have to file an affidavit.
Yes, lordship.
explaining why you are not considering his method.
Yes, lordship, that will be better.
The courts will not speak.
Yes. Yes. Lulu, 2 weeks time, Lulu.
Third, MSD Muchari, then standing counsel,
For secondary education,
secondary education. Is allowed how much time?
3 weeks.
It's allowed 3 weeks time to file contract. List the matter. You retain the records. Because this, see, your records also is only this.
Lordship, that's what.
Mind you, only that ground, my lord.
Nothing here.
Lordship, on the next occasion, maybe we'll get the proper records, your
Original
lordship.
record.
Lordship.
MSD Mushari, planning council secretary, shall also produce the original reports by the next.
My lord, any date, my lord, because person is
Is
suffering.
the matter on 24th?
I am always.
Make please, my lord, Mr. Gogoi has some lordship, item 4, 5 and 6 lordship and item 5 may be taken up.
One minute.
What is it?
I was in Lakes in court number 1. There, my lord, the writ appeal order, my lord, only reiterated the learned single judge's order, my lord. Whereby direction was issued, that my lord, you will have to go.
I have a
for
copy of that, lordship.
inspection again. And my lord, the DMA was directed to my lord, thereafter pass a order. If that be show, my lord, then it can be otherwise closed, my lord. Because my lord, the
Let
entire
me
issue is
submit my case, lordship.
regarding my
Three
lord,
cases. Let me place my case, lordship. Last occasion, lordship was asked me to produce the writ appeal order, lordship. I have a copy of that, lordship. And apart from that, lordship,
Yes. Inspection report is there?
well, there are two inspection, one inspection report is already there, my lord. During the pendency of the writ petition, there was an order passed that, my lord, we will have to go for a stress inspection again, my lord. And they have to consider it as per the, my lord, the relevant provisions. That was, my lord, against that order, the petitioner preferred a, my lord, writ appeal. In the writ appeal, my lord, while disposing of, my lord, the order of the learned single judge was reiterated.
So that's why it's a
Second, my lord, inquiry was not conducted because, my lord, after writ appeal matter is pending here. My lord, one thing I must say, my lord, by going by this order of the learned division bench, here it seems, my lord, the order, this particular order, after this order, nothing survives in the writ petition, because if we go for the second, my lord, inspection, we'll have to pass a speaking order as per this order of the division bench. And that will be a fresh cause of action. Either we allow it or we reject it.
lordship,
Because we
pray-
cannot go beyond this order.
I may be allowed to place because there are 3 writ petition, lordship. Here in this order, meanwhile, the director shall pass appropriate order in terms of the report which are concerning to the college, including the inspector as directed. There was no such inspection in terms of the learned single judge order. And by virtue of that, lordship, let me place.
No, what I'm saying is that since already a judicial order is directing you to have an inspection, why don't you do the inspection?
We'll
and
do that,
use
my
the-
lord. We are bound to do that, my lord.
And apart from, without doing that, lordship, they cancelled my rejected, I filed a writ petition, last writ petition, lordship, they rejected my NOC by the principal secretary. Item number 6, lordship, may I kindly peruse. I have annexed that, lordship. There are 2 orders by virtue of that, lordship, the director has passed the order, sorry, principal secretary. Kindly take up item writ petition number 1012 of 2022.
Yes, I'm on that.
Lordship, I'm coming. And my learned friend has filed the affidavit here, specifically stating that they will not allow any, no objection, lordship. Because page 59 is the impugn order, lordship, where the principal secretary without.
How long will you take, Mr. Gogoi, to have the second inspection?
My lord, they will have to constitute a committee. My lord, lordship will give us in that case, my lord, 3 weeks time. Whatever is the report, we will place it. Or if lordship gives us the liberty, we can take a decision, my lord.
My lord,
I allow it in.
I let me, lordship, I kindly peruse item 59. They will never grant me NOC, lordship. Because first, they have only one technical ground. They firstly make a committee, lordship. That committee never visited. Then second committee, third committee was by virtue of this honorable court order. And this committee found it's okay because PCI, Provincial Council of India, given approval after inspection. Why the state government, lordship? Kindly peruse page 59 order.
Mr. Majumdar.
Lordship, please.
There's already an order passed by this court.
Yes, yes.
To have a second inspection. let them have the second inspection and come back with the report.
Yeah.
After that, we'll decide your matter.
Lordship, with all respect, I am agree, but since the order has been passed rejecting my claim of NOC, Lordship, second inspection will not survive, Lordship, because second inspection will not.
Let us see what happens. Let us not come to a conclusion. before they
Lordship.
do the thing.
And apart from that, Lordship, it is nothing but my response submission.
We'll see.
I-
See, Gogo,
Lordship.
will give you just about 2 weeks time. By 2 weeks, you complete. If there's no inspection report by the next 2 weeks, then we'll consider this on merits.
And apart from that, Lordship,
Indicate in the order passed by the land division bench, reiterating the earlier order.
no,
That
this
may be indicated
No, no,
in-
not required. Where's the single bench order that?
single bench order is, Lordship, page. Single bench order is in the writ petition number 1998, Lordship. Last order 9/2021, Lordship.
9?
9/2021.
But Mr.
Just, Lordship, I am also showing one thing, Lordship. In that case, Lordship, I filed additional affidavit, page 8, Lordship. Their inspection report, what they have stated, what, Lordship. Just I am showing with all, for the hands of justice, Lordship, this man is suffering like anything, Lordship.
Page,
8 of my additional affidavit.
in which case?
In writ petition number 1998 of 2020. I filed my additional affidavit by virtue of which this order was passed by the honorable court, by this honorable court.
Yes.
Page 8, may kindly peruse, Lordship. This is a submission of the inspection report. Earlier inspection 22/1/2020. Lordship, their observation, next page, page 9, remarks. On the basis of the above and absolute non-cooperation of the authority of the proposed Hamake College Pharmacy Dental so and so, during inspection, the committee observed that earlier committee found, Lordship, everything okay, then this committee. Perhaps there is a lack of relevant supporting documents, perhaps, in respect of land registration society. That was, Lordship, considered by the Pharmacy Council earlier committee also. Just to deprive me, Lordship, I am coming, my learned friend has filed an affidavit, Lordship, in opposition, where they have come with another set of allegations that some cases public complaint FIR against me, Lordship. Just to deprive this petitioner, Lordship. With all respect, Lordship, this against re-inquiry will get nothing. Lordship, with all respect before this honorable court, by record of all this, Lordship, kindly pass appropriate order, because they will not allow me, Lordship, in inspection, they will raise again and again such things, Lordship.
You cooperate with the inspection also. And third PM Majumdar, then council. So,
And in spite of having court order, Lordship, they are passing rejected my NOC, Lordship.
this court, by order dated 9/2/2021, passed in WBC number 1998 of 2020, directed the authorities of the Health and Family Welfare Department of the state to reconstitute an inspection committee which shall re-inspect the petitioner's college on or before 15/2021 and submit this report before the Director of Medical Education Assam by 31/3/22. Thereafter, comma, the DME, Director Medical Education, Assam, shall, after considering the report submitted by the said reconstituted committee, shall take a decision as to whether NOC can be given to the petitioner college to start with D Farm and D Farm courses in it or not. It was also directed that the said inspection report of the reconstituted committee, as well as the decision of the Director of Medical Education, Assam, on the basis of the said report of the inspection committee pertaining to grant of NOC to the petitioner college to start with D Farm and D Farm course in it or not, shall be placed before this court in a sealed copy. All right. Mr. B. Gogoi, Leonard, Standing Counsel, Health Department.
Well, my statement may be recorded that, my lord, there are certain police cases being registered against this particular institution for granting.
That I'm not saying anything now.
Otherwise it is there in the.
Submits that the reconstituted inspection committee, that you have not yet constituted, isn't it?
No, my lord.
That the respondents have not yet constituted the inspection committee as directed by this court on 9/2/2021.
Lordship.
He however submits.
Lordship, I pray, Lordship, since the earlier committee, Lordship, repeated visits, my objection, Lordship, at least recorded for inspection. Otherwise, Lordship, this petitioner is suffering.
Question of objection, my lord. There is the order of this honorable court.
1 minute.
It will-
Submits that the authorities would reconstitute the inspection committee. And the committee would make its report within a period of 2 weeks. 2 weeks from today. So according, comma, the authorities of the Health and Family Welfare Department is directed to reconstitute an inspection committee who shall draft, who shall re-inspect the petitioner's college on or before 1 week.
Lordship.
1 week will suffice.
My lord, we'll make it 3 weeks, my lord. In the meantime, we'll do the needful, my lord.
On or
Indeed,
before the 10th of March 2022. Thereafter, comma, the report shall be submitted to the Director of Medical Education, Assam, by
17th, man.
17th of March 2022.
Lordship, the earlier committee who found that the entire institution is correct, Lordship, that is page 44.
The Director of Medical Education shall thereafter, on consideration of the report to be submitted, shall take a decision as to whether NOC can be given to the petitioner's college to start with D Farm and D Farm courses in the said college. So, the report of the reconstituted committee, as well as the decision of the Director of Medical Education, Assam, shall be produced before this court in a sealed copy. So, on a sealed copy by the next week, it will be fixed copy. List the matter again on.
Lordship, I pray, Lordship, the said committee may not be influenced by the earlier rejection or whatever, Lordship. Otherwise, they will take same decision, Lordship.
On 24th of March.
Kindly,
24th March.
Lordship.
kindly observe that, Lordship. They should not be influenced by the earlier rejection. They may not be.
on top you say, the reconstituted inspection committee, while inspecting the college of the petitioner, while inspecting the petitioner's college, shall not be influenced by any order of rejection which has been passed early.
Against the petitioner, Lordship.
Against the
All right.
Much obliged, Lordship.
Item 13.
Where's David? It's always present.
13.
Mushari, you're there?
Lordship. I'm for secondary education department. Petitioner.
None appears for petitioner, MS Kim with Ireland and the standing council.
For secondary education. department.
Secretary, I think, appears for the second period. It's the methods of two.
Obliged.
Fourteen to 17 order.
Please, Lordship, Lordship, this matter, Mr. NJ Khataniar is supposed to appear. Lordship, he's on legs in court number 18. So can be taken up after some time.
I am for the respondent.
Add
to my lord.
After some time.
Sometime. My lord.
Lordship, in item 18, Lordship, the honorable court has called for records, and entire record has been submitted before the court number. Now is number 3, Lordship. The records are there, Lordship. So matter may kindly leave before the court number 3, Lordship. That will be better, Lordship. We have Mr. B. Kosik, Vedanta Kosik, he has submitted all the records. He has just informed me, Lordship.
Who?
Vedanta Kosik, our colleague, Lordship.
Lordship, on last occasion, the matter came before the Honorable Justice Mr. Michael Courts, my lord. On that day, the record was perused on that court, my lord.
Which court?
I am for the petitioner, my lord.
No. Which court peruse the?
No, that cannot be, Lordship.
On
Cannot be.
Justice Michael Sir Court, on that day.
Records were submitted. I was informed the records were submitted before the court number 3, Lordship, earlier court number 4. So records were there, Lordship. So let it list before that particular court, Lordship. That will be better,
How
Lordship.
can I give a direction to list before that particular?
Let the Lordship,
Let
my
it
lord.
come next week, Lordship. So I need it.
Record may be called for, my lord, at 2.
That will not be possible.
Yes.
Lordship may be hard the matter and very simple issue, my lord.
Records were called for by this honorable court. It was submitted by the B. Kosik, Lordship. Let it come next week, Lordship. Will B. Kosik come, Lordship? Then he's also out of station today, Lordship.
Can it be posted on 3rd of March? Friday?
There's in the rooster, there's some direction.
Yes.
I'm picking up after 2020 methods.
Okay.
So
then, Lordship,
you can obtain it from the court master.
Yes, I will ask Mr. B. Kosik, but he has submitted the. I will let it come after
On
next week.
20th,
Next week
20th
or
March, my lord. Let the matter be posted on 20th March.
20.
20.
Okay. Third MS.
A. Vijayapura.
Vijayapura, then the council for petition on the first matter.
on behalf of B. Kosik,
Then it's standing council.
secondary education. On behalf of B. Kosik, Lordship.
This the matter appearing on behalf of the council, there's a standing council. This the matter on.
I'm for respondent number 5.
20 March.
Must have been.
90. This is only so one of receivable.
May please. In this case, my lord, lordship may kindly peruse the my lord Lozima course order dated 5/12/2022 regarding service, my lord.
Yes.
But in view of the my lord order, my lord, the matter may be my lord service may deemed to be complete as per my lord section 27 of the my lord General Clause Act.
No.
Because my lord, 5 already appeared and he filed affidavit, my lord. 6 he refused. We also my lord taken steps of Dosti service. I have also filed an affidavit regarding that my lord Dosti service. Lesson number 6 and 7 he refused to accept the my lord Dosti service also.
Where's your affidavit?
Yes, my lord, I have my lord, that is my lord flag my lord Dosti service filed on my lord 26/10/2002 my lord. It is marked as my lord. I have seen my lord.
Elementary, secondary.
Yeah, service. Lordship has found my letter. Paragraph 3 my letter of my affidavit page 14.
Principal has appeared?
Yes, my lord. He has appeared and also filed affidavit. My lord.
Can you take first steps again?
My lord, since my lord, there is some urgency, my lord, because my lord, he has refused, my lord, due to my lord, postal, my lord, that is also my lord refused, and my lord, justice has also refused.
Respondent number 7.
6 and 7 is the same, my lord. 6 is the my lord president, and 7 is the by name. By name. 6 is the president of the school managing committee, and Asadullah, he is the president, my lord. So he by name also, my lord, he has party. Same person, my lord.
You have taken Dusty also?
Yes, my lord. That is I have filed my lord affidavit, my lord.
But Mr. T. There was the proceedings, the law of the court, the 5. It appears that the respondent 6 and 7 refused to accept the notice by justice. Further, with regard to respondent number 6, answer notice has been received by with the postal remark within inverted commas refused by address. Accordingly, notice on respondent 6 and 7 shall be dealt with. List the matter for admission after 2 weeks.
In the next week, there is some urgency, my lord. Next week, because my lord, there is no.
Next week, there are just 2 days.
My lord, any date.
15th month.
Published, my lord.
God bless.
God bless.
Oh, my.
Hey, please, your lordship, can the matter may be taken after some time, your lordship? Mr. Senior Counsel, Mr. UK Nair is on legs.
In this case, I have some, this is a case where all matters cannot be taken adjournment in this manner. There has to be a limit. What has happened? No. What has happened in this case? I was a selected principal of a law college.
Your lordship, I'm not praying for adjournment, I'm praying for a time.
No, yes, I know. I mean, the time means at what time? Malad, lordship will take up at 2. Yes, Malad.
Let the court control the proceeding.
Yes, Lord.
You don't try to control.
No, no, no.
Yes.
In court number 1, a matter has been called for. So therefore, Mr. UKNR, he has rushed to the court number. He was just here right now. So he has prayed before this lordship, before this court to adjourn the time for the timing. It's not for the day. I'm not saying for the day.
Yeah, lordship will fix up at 2. I agree to it because in that case, I am also there.
My senior.
Yes, yes. I am also there in that case. At 2 o'clock.
21.
May it please your lordship. This matter, your lordship has heard in length, your lordship. On the last occasion, if your lordship remembers, that they have filed an affidavit. As per the direction of this honorable court, they have filed an affidavit bringing in on the draft rules and the
Yes.
vacancy position. My only concern is that
Affidavit been filed by the secretary.
My lord, director has filed the affidavit. There we have placed the, my lord, draft rules, my lord.
Correct.
My lord, now promotional avenue has been created. But it is yet to be, my lord, come up as a, my lord, 309 rules. So it is under consideration.
No, this now has observed that it was the director who filed the affidavit.
Yes, because, my lord, in the affidavit that we have filed earlier, we have stated that, my lord, the government has directed the director to frame the rules. He has framed it and director has forwarded to the government. Now it is lying with the government for final consideration.
So that's why we said secretary should file the affidavit.
My lord.
Have you seen the last order?
Yes, I have seen, my lord. According to what information I could gather from them, they have sent it to the personnel department. Personnel department has given certain observations and returned the file to us. So it is under consideration. What I pray is, my lord, if lordship disposes of this direction, this petition, directing the respondents, that is a health department, to complete whatever process is required and to, my lord, frame the rules. Thereafter, my lord, whatever is promotion revenue there, they will get the benefit.
See, I can't give a direction to the respondent to frame rule.
No. Since the rule draft has been framed, it is before this honorable court.
It is for you to
finalize it.
matter.
We need to
Yes,
finalize.
what do you say?
no, I object to that, your lordship. The reason is twofold, your lordship. As I have submitted before this honorable court on the last occasion, that this affidavit has been filed by the director. The secretary, under secretary has already filed an affidavit denying our claims. Now there is a contradictory affidavits are being filed. Now, one thing can be done. Yes, that is an admitted position. The long-standing practice in this department is that the assistant entomologist has been promoted to the cadre of DMO. And there are sufficient number of vacancies. We require only 3 vacancies, your lordship.
There are some reasons given why you are not being promoted.
Your lordship, those reasons cannot subside because they are not
So this
supported
court
by
said,
records.
after seeing the affidavit, additional affidavit filed by the director, we said we want to have that affidavit through the secretary.
But before that, may I, my lord, on last occasion, my lord, I was not present, my lord, when this order was passed. My lordship may kindly see the affidavit filed by respondent number 1.
Yes.
Just for a moment, my lord. Paragraph 6. There is no dispute, my lord, as been submitted by the other side. Paragraph 6, page number 3. It is filed by the Joint Secretary to the Government of Assam Health and Family Welfare Department. Respondent 1, 2, and 3. May I read the, my lord, of paragraph 6?
Yes.
The deponent begs to state the petitioner prayed for his promotion to the post of district malaria officer from the assistant entomologist, and accordingly, department has initiated the process of promotion and sought views from the other concerned department. In this regard, the person B department has offered their view, which is appended as below. Lordship, the relevant will be in the next page. Prepare separate service orders for direct recruitment and for promotion, specifying all the cadres, conditions, scale of pay, and refer back for views in separate files. Expedite the process of finalizing the draft service rules. Thereafter, Director of Health Services Assam by letter was requested to prepare service order and service rules as desired by the Personnel B department.
That's
So
fine.
government has directed. Accordingly, they have now prepared it.
He has done the. He
Yes.
has made the draft, submitted to you.
Yes.
That's why we said we want that draft rules.
Present status, what is?
That is the thing, the draft rules to be presented before this court by way of an affidavit.
That we have filed, my lord.
No, through the secretary, not the director.
My lord, that, yes. That I can do. Otherwise, my lord, the director has forwarded it, he has placed it otherwise.
That's why.
Yeah, along with the covering letter, my
The
lord.
problem is director has filed the affidavit. We said, let the secretary place. the affidavit.
Not so. Then, my lord, otherwise, my lord, same draft will come here, my lord.
Yes, yes.
Along with the updated instruction, I will place, my lord. Whether whatever.
Can it be taken up, your lordship, this petitions are languishing since the last 5 years. May I pray that if my friend can do that by Thursday or Friday,
This
is
my
only-
lord, it won't be possible.
or by next Tuesday, your lordship.
Because, my lord, they will have to.
Because on last
instruction
occasion, the order was very categorical.
See, by next 2 weeks, I'm not here. Therefore, if there's a hurry, I can release this.
No need, your lordship will fix it as and when lordship sits again.
That's the problem. But our Singha.
Yes, sir.
Also for petitioner. Mr. B. Gogoi, then the standing council, health department
My lord.
is allowed. How much time? I'll have to give you
My lord, they need
2 weeks,
2 weeks. ma'am.
2 weeks time.
Your lordship will fix it as and when your lordship sits, and within 1 week, he'll file it, your lordship.
My lord, the only is there, my lord, in the next week. So probably
As to file affidavit as directed by this court
by 17, my lord.
on 8/2/2023. Release the matter again on 21st March. I'm checking the. So, by then you file your affidavit.
My lord.
Let him file by 15th of March, your lordship, so that if I can,
won't be
if
possible.
required, I can file a reply. to that.
You can do that.
Obliged, ma'am.
Deeply obliged, your lordship.
Item 3, admission.
Item 3.
24, supply 24.
No, I supply motion to kindly mati do.
Item 24 of supplementary.
May I please as your lordship? May I please as your lordship? Lord, the matter relates to, my lord, a recruitment process which has been recently initiated in the education secondary department, my lord, pursuant to an advertisement dated 27/12/2022, my lord. My lordship was pleased to hear the matter yesterday also, my lord. And we are, my lord, the madrasa teacher eligibility test qualified candidate in the category of, my lord, my lord, lecturer, as well as in the, my lord, postgraduate section, my lord. Now, my lord, the government in the education secondary department, by way of this advertisement, my lordship may be pleased to find the advertisement at page 96, my lord, annexure 12.
Yes.
My lord may be pleased to find that the applications are invited from the eligible Indian citizen as defined in Article 5 to 8 of the Constitution of India and the permanent residents of Assam for filling up 1,385 vacancies of postgraduate teachers in the different provincialized higher secondary schools under the Directorate of Secondary Education Assam in the scale of pay of rupees so and so, so and so, so and so. So, my lord, we are only concerned with the postgraduate teacher post. Now, my lord, may kindly see the condition of recruitment at page 96, my lord. Conditions of recruitment. The applicant must be a postgraduate in the concerned subject with at least 50% marks or its equivalent from the recognized university. This clause 1 we have, my lord. Now, the difficulty arising out is of the clause 2, my lord. The applicant should have appeared and passed the higher secondary teachers eligibility test in the concerned cadre conducted by the government, scoring a minimum of 60% marks in case of unreserved category candidate and minimum of 55% marks. Now, my lord, admittedly, the government, my lord, a few years back has conducted this teacher eligibility test examination for the, my lord, higher secondary category for the appointment in postgraduate teachers. Now, my lord, we are the madrasa TET qualified candidate, and we are interested and intending to apply, my lord, in the category of Arabic subject. My lord, may be pleased to find this along with this advertisement, another notification the education department has notified. I have appended, my lord, this said notification at page 109, my lord. Page 109, my lord, in the heading, my lord, may be pleased to find that the district-wise, category-wise, and subject-wise vacancy of postgraduate teachers in the provincial schools in the Bengali medium schools. So, my lord, this is the category. My lord, may be pleased to find that the advanced Bengali, alternative English, Arabic, and Bengali. We are only concerned with the Arabic in the district of Karimganj, and that, my lord, may be pleased to find at page 110, my lord. Page 110, this Karimganj district, my lord, Arabic post, they have shown 4 numbers of vacancies they are intending to fill up in the instant recruitment process. Now, my lord, what has happened? How the madrasa TET qualified candidate were born, that is a history is long, my lord, is very lengthy history is there, my lord. Yesterday, I have also brought your lordship's kind notice, my lord, that in the year 2012, my lord, a recruitment process for the purpose of the appointment in the various provincialized madrasa institutions, my lord, was initiated by way of a notification dated, my lord, 12/9/2012. And, my lord, that notification was assailed before this honorable court that as these madrasa institutions are also at par with the secondary level schools, my lord, so therefore government cannot discriminate by, my lord, appointing teachers who do not have the TET qualification. So, my lord, when the matter was examined by the division bench of this honorable court, then the state respondents, my lord, has come up with a policy that yes, we are also going to appoint or man only the TET qualified candidate in these categories of institutions. Therefore, the TET recruitment process was revoked. Then, my lord, this notification at page 51, my lord, may kindly have a look, my lord. Page 51, Annexure 1. Notification dated, my lord, 30/08/2004. Teacher eligibility test of madrasa education for the unreserved post in the provincialized madrasa institution. So, my lord, this is this certain criteria and the guideline has been fixed, and the which category they are going to conduct the TET was also notified. My lord, may be pleased to find that serial number 1 is the lecturer. The candidate must possess the requisite educational qualification of MM with minimum 60% marks from State Madrasa Education Board Assam. My lord, MM is a, my lord, abbreviation. It means, my lord, Mumtazul Muhaddisin, and Arabic terminology, my lord, it is a postgraduate degree in Arabic, my lord, is an equivalent to MA in Arabic, which has been recognized by the state of Assam also, my lord. So, my lord, therefore, the government has treated this MM qualified, TET qualified candidate as a postgraduate degree holder. Now, my lord, the same thing has been reiterated at page 54, my lord, the table and the course curriculum, my lord, included for the purpose of this MM qualified is also there, my lord, at page 54. My lord, we as a candidate, my lord, applied under this notification and successfully passed out the said MM lecturer course, my lord, and we have also been certified that we have passed at page 58, Annexure 2 is our certificate, my lord. My lord, may have find that the category, this is the petitioner number 1. He has passed in the MM assistant teacher category. Out of 100, I have secured 72% of marks, my lord. That's why, my lord, I am eligible and qualified as a TET pass candidate. Exactly, my lord, similar for the other petitioner at page 59. He is also for lecturer 64. And the petitioner number 3, my lord, at page 60, 76. So we are all eligible and qualified. Now, my lord, what has happened when this TET qualified candidate was there? The government, my lord, there was not available TET pass candidate was available for the state of Assam for the general TET pass candidate. That's why, my lord, they wanted to man these madrasa TET qualified candidate in the general schools from the upper primary to, my lord, postgraduate level. So, my lord, this process was going on till 2019. But in the year, my lord, 2019, by way of a notification, government has abandoned, or, my lord, they said that we are not going to recruit the madrasa TET qualified candidate anymore because the structure, course and syllabus basing on which this madrasa TET examination was conducted is different with the general category of TET plus candidates. So therefore, both cannot in the same footing, Milord. That was the reason they have cited, and they have, Milord, discarded this madrasa TET qualified candidate general, not in the Arabic course or, Milord, the other stream. So, Milord, this decision of the government was assailed before this honorable court, and this honorable court was pleased to, Milord, accepted the decision of the government, Milord, and dismissed the writ petition. But while dismissing the writ petition, Milord, they have this honorable court has categorically observed a submission made by the respected Advocate General, Milord, and I have given a copy of the order yesterday also, Milord. Passed in WPC 4688 of 2020, to save the precious time of my lordship, I straight away bring your lordship's kind attention to paragraph 10, Milord, at page 148. My lord, paragraph 10, Milord, I may be allowed to read over, Milord. A stand has been taken by the learned Advocate General Assam that the MTET qualified Arabic and Hindi teachers were allowed to participate in the selection process initiated by the advertisement dated 11/3/2018. As there were dearth of candidates, the same position was also clarified by notification dated 3/11/2018. Subsequent to issuance of the impugned notification dated 5/1/2019, another notification dated 8/3/2019 was issued, further clarifying that MTET FM, pre-senior and MTET Hindi were treated to be qualified for Arabic and Hindi teachers in ME school. Therefore, this court is not interfering with the such decision not being under challenge. My lord, my lord, to bring into your lordship's kind notice of this paragraph is that, my lord, the stand of the government was very clear that they are going to, my lord, allow the madrasa TET Arabic category and Hindi category, my lord, in the general schools also. Now, my lord, what has happened? Even this development was there. Another advertisement was issued, my lord, and my lord may be pleased to find that advertisement, my lord, is at page my lord, 80, advertisement dated 7/9/2021, my lord. Same thing happens to the present petitioner also, my lord. In this advertisement, my lord, similar category of postgraduate teacher they have decided to man, my lord, and we are also interested in the Arabic category at serial number 5, my lord. When, my lord, we wanted to apply, responding to this advertisement, my lord, the same difficulty arose that the Arabic category, there was no provision in the online mode that the Arabic category of the madrasa TET was allowed to apply. So therefore, my lord, we approached before this honorable court that as we have been, my lord, in the Arabic category, we should be allowed to apply. Then, my lord, this honorable court in the interim protected us, my lord, at page 90, my lord, may kindly have a look, my lord, paragraph 7. In view of said submission made by the learned standing counsel for the secondary education department in the interim and till the next date of listing, it is provided that only in the event in the present recruitment drive of undertaken pursuant to the advertisement dated 7/9/2021, the respondent authorities envisage recruitment of the postgraduate/graduate teachers in Arabic language in the high schools and higher secondary school. The respondent authorities would devise ways and means to accept the candidature of the petitioners who claim to be holding the MTET qualification certificates, if required, by accepting the offline application. However, in the event the respondent authorities do not intend to make recruitment of the graduate teachers in Arabic language in the high schools and higher secondary school, then the aforesaid interim direction would not be applicable. But, my lord, it was an admitted position that they intended to fill up the Arabic post. So therefore, my lord, we applied offline. Those offline applications, my lord, I have taken instruction, my lord, from the petitioner. The recruitment process was already over, but till date, my lord, those offline application is pending unattended before the office, my lord. Then we also come up before my lordship with an interlocutory application also, my lord, to apprise that situation. And my lordship at page 94. Paragraph 7, my lord. Paragraph 5, 6, and 7 is relevant, my lord. In the IA, we made a prayer that, my lord, our offline application should be considered, and my lordship at paragraph 7 has clarified, my lord. It is made clear that in the event the respondent proceeds to fill up the post of postgraduate Arabic teacher pursuant to the advertisement dated 7/9/2021, then the application made by the petitioner offline shall be considered. However, in the event the respondent decides to go for a separate recruitment trial with required to the postgraduate teachers in Arabic language, the applications already made by the petitioner shall be taken into consideration, i.e. stands disposed of. Now the situation arises, my lord. In the instant advertisement also, my lord, they have decided to go for filling up the post of Arabic teacher. So today is the, my lord, last date of, my lord, applying online up to 12 midnight, my lord. So, my lord, as we have make out a, my lord, prima facie case is in our favor, as the government is accepting that the Arabic they are going to allow, my lord. So we should at least, our application should be allowed to participate, my lord, and that can be made subject to outcome of my lordship's decision, my lord.
Yes,
My lord.
What my learned friend is submitting, lordship. This is the story before the interval. After the interval, the story is totally different. The judgment which he is referring now. Lordship will kindly come to just, I am taking a cue from the last submission, page 87, where that interim order and the submission of the standing council was referred to. Lordship will kindly see page 87. Sultan Ahmed and two others, 5474 of 2021. Here, Lordship will kindly see order dated 8/10/2021. Heard A.R. Bhuya, Learned Council, also heard P. Chakraborty, Standing Council, Education. Three petitioners herein project that they have passed out Madrasa Teachers Eligibility Test held in January 2015 in the category of lecturer and MM assistant teachers. It is projected that in previous recruitment drive, MTET qualified lecturers and teachers were allowed to participate in recruitment for filling up the post of assistant teachers as primary as well as secondary level teachers, schools, that is high school and higher secondary school. It is also projected that by notification dated 21/10/11/2018 issued by the respondent number 1, it was provided that MTET qualified candidates were eligible to apply for the post of assistant teachers BA, assistant teachers BSc, Assamese language teacher in high school and higher secondary schools. However, by notification dated 5/1/2019, the respondent number 1 had cancelled his earlier notification of 21/11/2018, which is stated to be the subject matter of challenge in WPC 1051 of 2019, which is pending disposal before this court. Paragraph 3. Thereafter, an advertisement dated 18/8/2019 was issued for filling up the vacant post of assistant teachers of various categories in secondary schools. Thereafter, by WT message dated 19/8/2019, the respondent number 2 clarified that MTET qualified candidates in the category of assistant teachers BA and assistant teachers BSc were eligible to apply for the post of assistant teachers and BA and BSc in high school and higher secondary schools. However, the said WT message dated 19/8/2019 was withdrawn by another WT message of 22/8/2019 in view of notification of 5/1/2019. Lordship will mark this. It is submitted by the Learned Council for the petitioner that the WT message dated 22/8/2019 and notification dated 5/1/2019 are subject matters of challenge in WPC 6174 of 2019. Thereafter, wide notification dated 10/9/2020 issued by the respondent number 1, the MTET qualified candidates were disqualified for being recruited to the post of assistant teachers in LP, UP, secondary level schools, and it is submitted that the challenge made against the said notifications are pending before this court. Pausing here for a moment, may I place this notification before this honorable court?
I have given a video.
This will clarify everything, this notification. This is of 10th September 2020. May I place this whole notification? Because whole story is inserted here. Due to non-availability of TAP qualified candidates for recruitment in post of Arabic and Hindi teachers in provincialized schools, madrasas, the madrasa TAP qualified candidates of relevant subjects were allowed to apply for the post of subject teachers in Arabic in higher secondary schools, assistant teachers in Arabic in high schools, high madrasas, assistant teachers in Arabic in ME schools, ME madrasas, and assistant teachers in Hindi in ME schools, ME madrasas by government notification of 17/10/2015. In continuation of the said government notification of 17/10/2015, the qualified candidates of madrasa TAT in pre-senior section having all other required qualifications prescribed in the respective service rules were declared eligible to apply for the post of teachers in Arabic, social science, and general science in ME schools by government notification dated 29/10/2018. Further, in continuation of the aforesaid notification dated 17/10/2015 and dated 29/10/2018, it was ordered that the candidates who have qualified madrasa TAT for the post of assistant teachers in BA, BSc, and Assamese language teachers, having all other required qualifications prescribed in the service rules, shall be eligible to apply for the post of teachers in BA, BSc, and Assamese language teacher of ME, high school, high madrasa, and higher secondary schools in the interest of public service by government notification dated 21/11/2018. However, considering the differences in the structure, content, and also pattern and syllabus of teachers' eligibility test between madrasa education under secondary education and the general teachers' eligibility test under elementary education by government notification dated 29/10/2018 and notification dated 21/11/2018 were cancelled by government notification ASC so-and-so of 5/1/2019. Now, considering the fact that the teachers' eligibility test is already been conducted by the secondary education department for high school, higher secondary schools, and the elementary education department for LP and LP schools, and that there are sufficient number of TAT qualified candidates under secondary education and elementary education department for filling up of different categories of posts, the government notification dated 17/10/2015 and all other government notification allowing madrasa TAT qualified candidates apply for the post in high school, high madrasa, higher secondary schools under secondary education, and LPME schools under elementary educations are hereby cancelled with immediate effect. So initially, MTET was done. That was conducted so that they can be recruited. This is the notification for that, Lordship. If Lordship is pleased to take the writ petition. 51. Page 51. On the basis of this notification, all these persons have acquired MTET. Lordship will kindly see 30th October 2014. Teachers eligibility test of madrasa education for unreserved post in provincialized madrasa institutions. Specifically for madrasa institutions, that was conducted. In 2015, government decided that there are shortage of TAT qualified candidates who are applying for positions in provincialized madrasa schools. So they allowed that MTET qualified persons are also allowed to participate in the recruitment process. That continued till 2020. In the meantime, there was no TAT qualification, TAT examination held. Finally, in 2020 and 2021, 2 rounds of TAT examination was conducted, and at present, there is ample number of TAT qualified persons available for the recruitment process. There is a huge difference of TAT conducted for the madrasa institutions and TAT for the general provincialized institutions. One more very important aspect is that as on date, there is no provincialized madrasa in Assam. We have closed down all madrasas which are under government patronage, and they are amalgamated and brought under secondary education department as a provincialized government regular school. The madrasa board has also been dissolved. So everything is now under secondary education, and there is no madrasa institution as on date on government patronage or provincialized madrasas. The private madrasas are operating. There is no issue on that. So this notification which I have placed, that is of 10 September 2020, by which all these madrasa qualified candidates, they will not be considered for to apply for the post in high school, high madrasa schools, higher secondary schools under secondary education, and LPME under elementary education. So this is a general notification issued applicable to all, lock, stock and barrel, everything, everybody is coming under the umbrella of this particular notification of 10 September 2020. Now this was put to challenge. This is the judgment, Lordship. It has already been given. So when the learned standing council made that submission in that interim stage, which my learned friend was placing, and I was also just referring, page 88 and 89 of the writ petition. The submission at paragraph 7 at page 90. For a moment, I'll come to the judgment. I have placed paragraph 2 and 3 and paragraph 7 now, because my learned friend referred to paragraph 7. In view of the above said submission made by the Standing Council of the Secondary Education in the interim and till next date of listing, it is provided that only in the event of present recruitment drive of undertaking pursuant to the advertisement of 7/9/2021, the respondent authorities envisage recruitment of postgraduate, graduate teachers in Arabic language in high school and higher secondary schools. The respondent authorities would devise ways and means to accept the candidature of the petitioner who claim to be holding MTET qualification certificates if required by accepting offline applications. However, in the event the respondent authorities do not intend to make recruitment to postgraduate and graduate teachers in Arabic in the high school and higher secondary, then the aforesaid interim direction would not be applicable. On the basis of this, Lordship, in paragraph 6 also, at the outset, the Learned Standing Council for the respondent has submitted that as per instructions received by her, a separate recruitment process would be undertaken for postgraduate Arabic teachers, and that the petitioners who are MTET qualified may apply in such recruitment drive. So this was a submission at that interim stage, where the subject matter also includes the challenge of this notification of 10/9/2020. This has finally been decided. All these interim orders have no meaning today. When finally this honorable court by the judgment in WPC 488/2020 and other all connected cases, the judgment was delivered on 5th of April 2022. All the case numbers are not included, only the first page of the clause title, and the judgment is at second page, which starts at 118. So from page 1 to 117, all the cases were heard together, which included a challenge to this notification. Here, paragraph 1 heard so and so, all the case numbers are here. Also heard A.R. Bhuya, my learned friend, for the petitioner in WPC 4688, etc. M. Mullah for 4785, B. Purkasa, and I appear for the state of Assam. So here, the challenge, paragraph 2. The first challenge is the notification of 5/1/2019, whereby notification dated 29/10/2018 and 21/11/2018 were withdrawn. The notification dated 29/10/2018 and 21/11/2000 were issued, allowing petitioners who had qualified madrasa TET examination to participate in a selection process initiated by an advertisement of 11/3/2018. These petitioners had qualified madrasa TET examination for higher second HS pre-sections, AFM pre-sec senior and assistant teachers, etc. The other challenge is the notification of 10/9/2020, which I have placed, whereby all earlier notifications allowing Madrasa TET qualified teachers, including Hindi and Arabic teachers, Lordship will also to participate in the selection process for selection of teachers in upper primary, lower primary, under secondary, and elementary education departments were cancelled. These Madrasa TET, these qualified candidates in Hindi and Arabic teachers were earlier allowed to participate in the selection process initiated by advertisement of 11/3/2018. The third challenge is the advertisement of 11/9/2020 and 24/9/2020, which were issued for filling up the posts of graduate teachers in science and arts in provincialized high and higher secondary schools in Assam. So now this present advertisement is also recruitment of teachers, graduate and postgraduate in provincialized schools under secondary education department. It is not for any Madrasa education institutions. Here, the backgrounds are there. Undisputed facts, all these things which I have already placed. 3.1. The government of Assam in secondary education by way of advertisement on 3/8/2014 initiated the process of conducting teachers eligible tests for Madrasa institutions with a view of offering quality education in provincialized Madrasa institutions, in short AMTET. The petitioners participated in the said TET examination for assistant teachers, HS, etc. Then the narration of the subsequent notifications. At page 123, internal page, Roman 11/12. Thereafter, on 11/9/2020, another advertisement was issued for the filling up of the post of graduate, etc. Then 13. Yet another advertisement was issued for filling up the post of assistant teachers in upper primary and lower primary on contractual basis. Then Senior Counsel K.K. Mohanto's submission that promissory estoppel aspects were brought in. From our side, the government stand before this court was paragraph 7, page 127. Different kind of TETs are being held in Assam. This is government's version. Different kinds of TETs are being held in Assam. The first is a general TET for Assam known as Assam TET, meant for recruitment of teachers in general schools. There are some Shiksha Mitra working in different UP and LP schools who sought for their regulation. As no order of regulation could be made, these Shiksha Mitras were given a chance so that they can get qualified for their absorption. Accordingly, a special TET for Shiksha Mitra was also held. As the 6 scheduled areas of Assam were not having sufficient number of qualified teachers from those areas, the state of Assam has also taken a decision to have a special TET for 6 scheduled areas so as to give an opportunity to the persons, candidates who are residents of 6 scheduled areas. Today also an advertisement is issued for 6 scheduled areas TET. Accordingly, TET for 6 scheduled areas was held. The government of Assam also took a conscious decision to have a separate TET for madrasas for purpose of appointment of teachers in madrasa schools. Keeping in mind the syllabus, etc. of madrasa schools, accordingly, the madrasa TET was held. Thereafter, the decision to hold madrasa TET was pursuant to the decision of the division bench in order dated 22/1/2014, passed in PIL so and so, wherein an undertaking was given on behalf of the state of Assam that a decision to introduce teachers eligibility test for recruitment of teachers in provincialized madrasas has already been taken. Accordingly, the said PIL was disposed of with the observation that state shall comply with the undertaking. So thereafter, this 2014 TET was conducted. Roman 8, down below. There are marked difference between the structure, syllabus, etc. between the general TET and the madrasa TET, in as much as madrasa TET was conducted only for recruitment of teachers in provincialized madrasas and not for general schools. The intervening decision between holding madrasa TET and allowing some persons having qualification of madrasa TET to participate in the selection process of general school was erroneous, in as much as said decision was in contravention of the central legislation, that is RT Act of 2009. This is regarding the elementary part. So I'm skipping everything now. What is the finding of the Honorable Court? Page 141, one of the finding, that is 17, Roman 17, a comparison of both the guidelines dated 11 to 2011 issued by the NCT and the advertisement of so-and-so clearly reflect difference in structure, content, marks. However, this court is not entering into the arena whether such difference is laid in the advertisement of 2014 is in contravention of NCT guidelines. Finally, Lordship, the Honorable Court was pleased to uphold the notification of 10th of September 2020. Page 148. Paragraph 10, a stand has been taken by the learned AG Assam that the MTET qualified Arabic and Hindi teachers were allowed to participate in selection process initiated by advertisement of 11/3/2018 as there was dearth of candidates. The same position was clarified by notification of 3/11/2018. Subsequent to issuance of the impugned notification dated 5/1/2019, and another notification of 8/3/2019 was issued further clarifying that MTET FM and MTET Hindi were treated to be qualified for Arabic and Hindi teachers in ME school. Therefore, this court is not interfering with such decision, not being under challenge. This was in respect of 2018's advertisement. At that point of time, the 2020 and 2021 step was not held. There was dearth of candidates. That is why the government took a decision and this was conveyed to the court. That will not give them a right for a recruitment process initiated in the fag end of on 27th of December 2022. Paragraph 11. However, the decision reached out by the court shall be applicable to the notification of 10/9/2020 and advertisement of 11/9/2020 and dated so and so. The impugned order of 10/9/2020 cancel all earlier notifications allowing MTET qualified candidates to participate in the selection process, including the notification of 17/10/2015 allowing MTET FM and MTET Hindi qualified teachers. No specific relaxation has been granted in favor of MTET FM pre-senior MTET Hindi to the Learned Advocate General has verbally submitted the status allowing MTET FM pre-senior MTET to participate in selection process relating to appointment of Hindi and Arabic teachers in provincialized schools, as they need to teach in their respective subjects, Arabic and Hindi, and not any other subject. However, submission is contrary to the notification of 10/9/2020, and no subsequent notification has been placed on record recalling the notification of 10/9/2020, so far as relating to MTET FM and MTET Hindi. Therefore, it is made clear that though this court is not interfering with the notification of 10/9/2020, the reasons enumerated herein above, the state is at liberty to take fresh decision in this regard, as has been submitted by the Learned AG Assam verbally. In terms of aforesaid discussion, reasons and observations, this petition stands dismissed. Interim order, if any, stands vacated. So finally, the Honorable Court upheld the notification of 10th September 2020, which disallows or disentitles all MTET qualified persons from participating in a recruitment process on the basis of MTET qualification for any post in general and regular schools. This is now put to challenge before the division bench. The Honorable Court has not passed any stay order. So this order is holding the field as on date. Our situation in allowing in 2018 was totally different because during that period, there is a huge gap of 4 or 5 years. No TET was held and there was acute shortage. Now the situation is reverse. So my humble submission is that as this notification of 10th September 2020, which bars everybody having MTET to participate in this recruitment process, and there is a judicial exercise, scrutiny of this notification also, and the Honorable Court did not find any infirmity or arbitrariness or unreasonableness or illegality in this notification. Because the streams are totally different. Syllabus is different, content is different, marking is different, total marks is different. So there is no infirmity in the government's decision. And on top of that, as on date, Madrasa TET qualified persons cannot have anything for government post because we are not running any provincialized madrasa as on date. That was also put to challenge and that was also upheld by the division bench. Because with government fund, we cannot impart any religious education in government institutions. Whether it is a Christian institution, Hindu institution, or Islamic institution. There is a strict bar under clause this article 26-25 of the Constitution of India. 28(1) to be precise. And that is also again put in the Supreme Court. It is in session of the Honorable Supreme Court whether we have done the right thing or wrong thing. But that is along with the madrasas, we have also closed the Sanskrit tolls. Sanskrit tolls, they did not challenge. Madrasas, they have challenged. And after long deliberations and hearing, Lordship, it was upheld. So this notification was also upheld. So MTET candidates cannot participate in a recruitment process of a regular government school. It is as simple as that. And in the challenge, a coordinate bench of this honorable court upheld that decision of the government. So if whatever they are praying that they should be allowed to submit their applications, that will be totally in conflict with this judgment. And till now, the division bench has not interfered with the learned single judge's order at the interim stage. So this is my humble submission at this stage.
My lord. My lord, with all the respect, submission made by the learned advocate. The issue is, my lord, regarding this decision of the my lord coordinate bench, my lord. It is now sub judice before the division bench, my lord, and the division bench has taken a view to hear the entire matter and dispose of the same. And my lord, incidentally, tomorrow the matter has also been listed. Now, my lord, in a situation, if this, my lord, the learned single judge order is interfered with, my lord. Suppose, my lord, tomorrow or day after tomorrow or any day it is going to be interfered with, my lord, then the entire scene will be reversed, my lord. And then the last date of my lord submission is the today, my lord. So we are going to miss the bus. So, my lord, my only limited prayer, my lord, is that our application we should be allowed to apply. We are not asking for a job. Government is always open, my lord, by citing the reason. They can, my lord, reject us at any moment, my lord. Now, if we cannot apply, my lord, if a situation arises tomorrow that this learned single judge's order, my lord, which we have assailed in a writ appeal, my lord, if going to be interfered with, then this entire thing will be go, my lord. And secondly, my lord, the discretion has been given to the state, my lord. It is not that at the one go, the entire thing has been negated by the learned single judge. If my lord may be pleased to take up the paragraph 11 is very clear, my lord. If for a moment, if I may be allowed to reiterate, my lord, the paragraph 11. My lord, if my lord, it has said that although the notification has not been interfered with, my lord, but it has been left at the ipse dixit of the state that they can make a policy, and the statement of the my lord advocate general before the court, my lord, is a constitutional statement, my lord. So, my lord, with all respect, although there is no notification is governing, but a constitutional body, my lord, giving a statement before this honorable court has a bearing in law. And secondly, my lord, at this moment, my lord, if we cannot apply, my lord, then we will miss the entire bus. And secondly, my lord, my respected advocate general has said that we have allowed participation of the madrasa TET and even appointment has also been given. Now, from the same class of people, my lord, they have, when there was no available candidate for them, general TET, they have allowed the madrasa TET to be appointed in the general schools. Now, my lord, they have said, now we have enough candidate, we are not going to allow the madrasa TET. This is a clear discrimination, my lord, violation of Article 14, creation of two different classes of people from the same class. That is also, my lord.
That you have already argued.
My lord,
in the previous.
my lord, that we have argued that has been, my lord, negated by the my lord single judge. And now the situation, my lord, is that if we cannot apply, my lord, and this honorable court and the writ petition, my lord, which I have brought into your lordship's kind notice, that writ petition has not been disposed of. Till date, it is pending, my lord. The earlier interim order which I have relied on, and that is on a different footing. There is no connection with this batch of petition which has been disposed of. So, and my lord, we are especially asking for the Arabic postgraduate, my lord, and the learned single judge, my lord, which has been relied on not on the postgraduate course curriculum, my lord. It is only to the upper primary and secondary level BA, BSc category, my lord. So therefore, my lord, the government is also, my lord, considering this pass candidate to be appointed in the graduate as well as in the postgraduate cadre, my lord. Even in the 2018 rule for the Arabic, my lord, they are giving preference to the candidate having that, my lord, degree, my lord. So, my lord, therefore, on the one hand, they are giving the preference to the, my lord, degree holder. And on the other hand, my lord, they are saying that we are not going to allow this madrasa TET, especially for this, my lord, Arabic. We are not asking for the general category, my lord. So that is the situation here. Now, my lord, the government, when these madrasa institutions were existing, my lord, they have conducted the TET examination for the madrasa. Now they have abolished the madrasa. Where we will go, my lord? What will be the happen to the our qualification, my lord? At least government being a welfare country, my lord, they could have accommodated in the institutions where we are, my lord, entitled to. That has not been done, my lord. It is a completely an arbitrary act, my lord.
When the issue is 10th September 2022, notification is still in force.
No, still in force, but that is under, my lord, examination before the division bench, my lord.
That is correct.
My lord, my
But
lord.
till that, no order has been passed.
No, my lord, if tomorrow or day after tomorrow, my lord, if it
That is
happens,
the unfortunate part,
my lord.
because your deadline is today.
But that's why, my lord, let us be provisionally allowed to apply, my lord. Let us be
How
provision,
can I allow you?
my lord.
How can I allow you in, when there is a bar in view of the notification of 2020?
No, my lord, that bar is only for the general category, my lord. If I am not wrongly understand, my lord, no, kindly,
It says
my lord,
initially you are allowed to appear because they have dearth of candidates.
my lord. my
But
lord.
now they have sufficient candidates, and therefore you will not be allowed to.
That I can understand, my lord. That is the policy of the government, my lord.
Now,
And-
beyond that, I can't do anything.
But my lord,
And this court, while disposing of the batch of writ
my
petition,
lord,
dismissing,
dismissing, my lord. Yes, my lord.
gave liberty to the state only, liberty only.
My
But then they have not taken that liberty. They have decided to proceed with this notification.
But my lord, in the judgment, it has said that the state is allowing the so-and-so to participate in the selection process relating to appointment of Hindi and Arabic teachers in provincialized school as they need to teach their respective subjects only, that is Arabic and Hindi, and not any other subject. However, such submission is contrary to the notification dated so-and-so, and no subsequent notification has been placed on record recalling the notification dated so-and-so so far relating to the MTET, FM, senior and MTET Hindi. Now, my lord, we are MTET and the entire examination was done in respect of, my lord, MTET FM and MTET Hindi, my lord. Now, that's why, my lord, the issue as regard that whether this MTET and lecturer can be allowed for the postgraduate degree or not, that my lordship is always open to examine, my lord. At least, my lord, we may be allowed to apply. And, my lord, if we cannot allow to apply, my lord, then we are going to miss the bus, my lord. That much interim order I am, my lord, praying for, my lord, fervently, my lord. They can reject also, my lord, by citing this judgment or that reason also, my lord.
I don't think
My lord,
I'll have to dispose of this.
my lord. That is my respectful.
And there is a huge delay. On 27th of January, December, the advertisement was issued.
No, my lord, yes,
They
yes.
came last moment.
No, my
at the
lord,
11th hour. That is number one. Number two, if the appeal is pending and they are expecting hearing date in a day or two, they could have filed an application for early hearing because the order is of April 2022.
No, it was.
If they are so hurry, during the course of last 2 months also, they could have expedited the hearing before the learned division bench.
No, my lord, my respected advocate general is very correct. That is 2712. But the number of posts and the subject and category has been notified on last part of February, my lord. It is in the website, my lord. From the website only we could come to know that this is going to happen, my lord. Arabic, my lord. Now, my lord, this closure of this Arabic, this madrasa institution, my lord. Now, my lord, once if the madrasa institution were in existence, then we could have, my lord, apply for those categories of posts. Now, the entire issue of the closure of madrasa institution is sub judice before the Honorable Apex Court also, my lord. That, my lord, if something happens in future, then everything will again get revived, my lord. Now, my lord, we are a redundant product. The government has, my lord, give us birth for the purpose of madrasa institution. Now they have thrown out us that we cannot, we are a redundant product and we cannot go for any job.
All the madrasa teachers, we have absorbed them in secondary education department.
My lord,
They are all without us.
my lord.
They could not get any job from 2014.
But my lord, now they have said
They are
that
never part of the system.
those were absorbed, my lord. Those are absorbed. Those are belong to the same class of people, my lord. My colleagues, my lord batchmate, they have get appointment. Now their policy is there that now we are not going to take up. This is a completely in violation of Article 14, my lord. My lord.
I don't think I can help you. Mr. Dean.
My lord.
But yeah, Boyan, when it comes. Also heard Mr. D cycle and Advocate General Assam for the all respondents.
Lordship.
Except by Mr. Executive District, then extending conflict.
Yes.
Secondary.
Yes, Lordship.
Yes, yes, my lord. All are secondary.
Secondary.
RMSC is also there.
Yes, yes. I mean,
The petitioner are all MTech. MM, is it?
My lord, MM and lecturer.
Are all MTech, MM and lecturers who are intending to apply for the post of graduate teachers,
Postgraduate teachers.
for the post of postgraduate teachers in different provincialized secondary schools. In terms of the advertisement, dated 27/12/2022, issued by the who issued this?
Not by the director.
By the director of secondary. Assam. In the said advertisement dated 27/12/2022, applications were invited for filling up 131,385 vacant of postgraduate teaching in different provincialized secondary schools. So, Clause 2 of the conditions of recruitment in the said advertisement reads as under. A2. Para. It is the case of the petitioner. That as they are MTech, comma, they are barred from applying for the said post of postgraduate teachers in due to clause 2 of the conditions of recruitment. Therefore, the prayer of the petition in this petition is to permit them to apply provisional despite not having the qualification as prescribed in the advertisement of the 27th. Learned Advocate General, Assam, on the other hand, submits that there is a bar on for the petitioner to apply for the post of postgraduate teachers in different provincialized secondary schools in advertised by the advertisement date 27/12/2022 in view of the notification dated 10 September 2020 issued by the Secondary Education Department. Which provides that all government notifications allowing madrasa TET qualification in to apply for the post in high schools, public high madrasas, public higher secondary schools under secondary education, and LP public ME schools under elementary education are hereby cancelled immediately. He also submits that the said notification dated 10 September 2020 was challenged in WBC number 4688 of 2020, along with other batch of writ petitions, which were however dismissed by order date, judgment in order dated 5/4/2020. In that view of the matter, as the notification dated 10 September 2023 still holds the field till date, no concession can be given to the but after hearing the learned counsel of the party and on consideration of the materials available on particularly the advertisement dated 27/12/2020 calling for application for filling up 1385 vacancies of postgraduate teachers in different provincialized secondary schools. This court is of the view that the advertisement dated 27/12/2022 bars the petitioners who are applying for the said post that have been advertised due to the fact that they do not possess the higher secondary teachers eligibility test within bracket here. So the petitioners are only MPhets, and therefore the close to of the advertisement dated 27/12/2022 does not permit them to apply for the said course as they are lacking in educational qualifications. A further reading of the notification dated 10 September 2020 also clearly indicates that madrasa TET qualified candidates are barred from applying for the post in high schools, high madrasas, higher secondary schools under secondary education, and LP/ME schools under elementary education department. The said notification was a subject matter of challenge in WBC 4688 of 2020, which was however dismissed by the judgment note dated 5/4/2020. It is not disputed at the bar that the order dated the judgment in order dated 5/4/2020 is under passed in WBC 4688 of 2020 and other batch of petition are before the Honorable Division Bench in appeal. However, It is not disputed at the bar that no orders has been passed. No orders has been passed.
No stay order has
No,
been
no
passed.
stay order has been passed in the said appeal. Passed. On the consideration of what has been stated here now. This court is of the considered opinion that as the notification dated 10 September 2020 still holds the field, I am unable to accept the prayer of the petitioner in present and accordingly defend this distance. However, with no order.
Deeply obliged, my lord.
এখন পেলাই দিয়ে এখন কাম নাই কি 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 সুধিব লাগে
কেতিয়া হ'ব
এসি মানে
কি বুজি কিবা ইনস্পেক্টৰ হয় নে কিবা এক্সাম দিয়ে
ইনস্পেক্টৰ বিলাকৰ
কেতিয়া মানে হ'ব
আৰু সেই নহয় এই যে
সুধিলো এতিয়া হ'ব নহয় আমাৰ কিমান তিনিটো আমাৰ 2টা বজাত ল'ব নে বাইদেউ
যাবই পাৰে ইয়াতে এনেকুৱা
The broker is closing down today.
And the Lakhimpur has already closed.
Notice the date, Lordship, 23/8/2022. Today is the last date.
Yes.
And the students have been placed where?
Lordship,
And
no, Lordship, they are already admitted in a school, Lordship. But they are dropout, so they were placed under the that particular center, Lordship, to prepare them for mitigating the drop period, Lordship. Now, as the school center has closed from, is closing from today, Lordship, they have been, they are going to be placed under the school itself, Lord.
under the school.
Yes, Lord.
Then
In which they were already their student, I mean, enrolled there, Lord.
Also, let them file an affidavit and investigate.
up to you. But Mr. N.J. Gogol and the counsel for petitioner, if you notice. Mr.
Tina,
You are for?
I am for SSA authority, Lord.
Who appears for chief secretary?
I am affidavit.
D. Bukalia and the government appears for respondent. One and five.
Not one, only one.
Lordship, I am appearing for 2 and 4.
Who appears for elementary?
5 for the sake. It is going to case.
22 to know. Mummy go on, huh?
ये बात इसे मेरी जुम्मन दुकान है
June month, second, अपना 23 to this.
23 जुम्मन दुकान 22 मम्मी
Elementary Tamil Nadu.
এটা কই লিয়া কোন আছে এলিমেন্টারি নাম এটা কই দিলে হল
Your may record SMT is this name, he is in the code also.
Is elementary.
Elementary also he.
Mr. Assembly, still understanding council elementary appears for respondent. One, two. 2 and 3. And Mr. P. Nayak, understanding council.
SSL.
Four. Finance also you are there?
Finance I am appearing, Lord. Lordship may record A. Sali has named Lordship.
For respondent, 4 and 6, Mr. A. Chalia, understanding council, finance for respondent. Notice on respondents are complete. Respondents are allowed to have. This matter has to go.
I love this.
This is which?
Well, this is Lakhimpur district.
Lakhimpur also closed down.
Lakhimpur it was closed on 31st of January itself.
That's closed down.
My lord, with regard to Lakhimpur district, my lord has passed an order, my lord, that is on record, my lord, WPC 592. That is on record, my lord, with regard to the district of Lakhimpur.
Where is it?
I pray for a similar order, my lord, if they are entitled, my lord.
No, Lakhimpur, they've already closed down.
No.
Close. 31st January to close. January to close.
January.
Then
My lord, this order was passed in February. Lordship will kindly see, my lord. So similarly situated, my lord. Similarly
where is
situated.
this order, that early order?
No, earlier, my lord, passed in
30/11/2022 order. It was passed on the basis of that order only.
Yes, my lord.
Where's the 30/11/2022 order?
My lord,
WBC 7001 of
7001, yes, my lord, that is was with regard to district of Kamrup, my lord.
yes, but
My lord will kindly see 592, my lord, WBC 592 of 2023. The order is there, my lord.
I'm on that. This
Yes.
court did not say much. It just says that it is covered by the order passed by.
Well, let's say that much, my lord, nothing more, my lord.
I want to see what order was passed in the WBC 700.
Yes, my lord will kindly take up the petition, my lord, as 59, my lord,
Page 59.
59. 64 onwards, my lord, the operating part, my lord. The direction, my lord, will find at page 68, paragraph 21.
Cannot be, I cannot pass this on. Once the institution has shut down, I can't pass this on.
They're continuing. They're continuing, they're going to,
Are they continuing, Mr. Nair?
The confusion is the center and the school is the same place, Lordship. That is why they are giving the impression that it is children, children are continuing. That is not actually the fact, Lord. The center is no more working there.
Center is no more there. It has shut down. How can I pass an order for allow you to continue?
Also been my humble submission, Lordship, they should not raise this matter anymore, Lordship, because from April, Lordship, they are again going to be considered, Lordship. Scheme is starting from April again, Lordship. So they are continuing on that basis only, Lord.
let them continue then till then, that time, my lord.
Once the center has closed down and you are no more there, how can I ask you to continue?
To my instructions, my lord, they have not shut down the training center, my lord.
Then let them file an affidavit.
Till then. But till a
No.
finding is reached, my lord.
I can pass an order asking them to file an affidavit. Beyond that, I can't pass it. It's up to you. If you want that notice, I'll issue that notice. Otherwise- Or you can withdraw it. There's no point. There's no point in pressing this type of writ petition. You know the center has closed down. So what is the point
No,
of
my lord,
pressing?
to the instruction, as per my instruction of my clients. my lord.
Once the affidavit comes again, your case will be worse. It's up to you.
Then,
You want notice to go?
Then lordship, my lord, will kindly issue the notice, my lord.
But Mr.
PK Munir, man.
P.K. Monil and the counsel for petitioner issue notice. Here also who appears.
Online.
Commissioner and Secretary Elementary,
I mean,
1 and 3.
1 and 3, my lord. I'm a.
MS
And
and Pukan and the standing council elementary appears correspondence 1 and 3. And Mr. D. Nayak and the standing council.
2 and 4, Lord.
Respondents have a-
my lord, may I pray for an observation, my lord? If the center is not closed, my lord, the petitioners may continue with their service, my lord. If not closed, if closed, my lord, then
It's a matter of proposal. What center is it?
it is Aziz Borua's training center. My lord. There are different training centers, my lord. Lordship will find that at page 11 of the writ petition, my lord, there are 8 different training centers, my lord. A chart has been given, my lord, for lordship's convenience.
Page
Page 11, my lord.
In the interim, it is provided that if the centers in which the petitioners are appointed is not closed down, comma, they may be allowed to continue.
I'm deeply obliged.
Free of daily list for admission. She lossy almost I have completed, just I have reiterated lossy.
What matter was this? Now I'm focusing.
This matter is regarding lossy, whether panel list should be more than one or not lossy. Within this. Only lossy says hard it lossy. And we have placed our submission also lossy.
Yes.
Lossy. Lossy, again I refresh all lossy, otherwise I have almost completed.
Yeah.
So again I have refreshed lossy.
It's up to you if you want to.
If lossy then required I can press
Okay.
lordship. The matter before your lordship is that we have rejected the claim of the petitioner lordship. Only ground that lordship, it's a lordship, the third candidate is sent to us lordship. So this recommendation cannot be accepted at this stage, lordship. Because lordship, the petitioner claim before his death lordship, the recommendation was sent by the governing body of the college lordship. Till today, we have not taking any decision lordship. If I go by my lord judgment, then it should be treated as a P measure one also lordship. Because till that, no finality attained in this case lordship. And petitioner case is that lordship, the governing body can prepare a panel list lordship. And accordingly, their case before this honorable court is that lordship, they are entitled as per the panel list. And our stand is that lordship, there is no provisions for preparation of the panel list lordship. In last occasion, lordship, I have submitted in this point lordship.
Yes.
And regarding my lordship, I have also pray before your my lord to put lordship to lordship moot questions lordship. Regarding lordship, whether a panel list, whether the authority can act upon the panel list lordship, which is not permitted under the statutory provisions of law lordship. And next question was next moot question was lordship, whether the notifications and letter override the statutory provisions of the law lordship. Whether any notifications or letter issued by executive authority can override the statutory provisions of law.
Yeah.
That two aspects I have already argued lordship.
Yes, I remember.
Lordship. That particular lordship, the college is provincialized under the lordship 2005 Act lordship. So it's 2005 Act lordship. And it's governed by the provisions of 2005 Act. In the 2005 Act lordship, there is a sections 15 lordship, where there is a power of rule making power lordship. On the basis of that lordship, the government, the legislature has enacted the rules 2010 rules lordship. That particular rule is applicable in the petitioner's case. My seniors are.
Let us see the act.
Act lordship. 2005 Act lordship. 2005 21 page of the lordship, it's in 490 lordship. 490 lordship. 490 lordship. This is the act lordship, which is governed lordship, the case of the petitioner's college lordship. Petitioner's college is the Jaji Hamnath college lordship. And this college is governed by the 2005 Act lordship. And here lordship, the Sunari college, that college Sunari college lordship.
and rule section 12 lordship. Section 12 of 2005 Act lordship. There is a power of the government to make rules lordship. Section 12 lordship. On the basis of that lordship, under the power given under section 12 lordship, the 2010 rules is lordship.
Where is that?
Next page lordship, 496 lordship. 496. 2010 rules is enacted lordship. And it's published in the Assam Gazette on 22nd November 2010 lordship. The post in question here is a lecturer or assistant professor lordship. Lecturer or assistant professor, so lordship rule 5 is applicable here lordship. Rule 5.2 lordship. Rule 5.2 is applicable for the post of lecturers librarian appointment shall be made by the direct recruitment with prescribed qualification for open advertisement in 2 leading daily at least in 2 consecutive issues lordship. Then lordship 7, next page lordship. In all these cases, the governing body shall conduct the selection process and recommend to the director who shall issue order of appointment lordship. The lordship wording of the statute is very specific lordship. In all these cases lordship, governing body shall conduct the selection process and recommend to the director who shall issue orders of appointment lordship. There is no provisions for lordship sending the panel list lordship. Only the selected candidate should be sent lordship and he should be appointed lordship. Then lordship 7, direct recruitment rules lordship. This is the statutory provisions lordship. This is applicable in the petitioner's case lordship. Our contention is that lordship, there is no any provisions. There is no any provisions lordship regarding preparation of select list. There is a statutory bar lordship. The select list or panel list should contain the equal number of vacancies lordship. Beyond that, we cannot lordship.
Where is that?
Lordship, I will place it lordship. First lordship, kindly come the advertisement, page 27 lordship, page 27 lordship, page 23 lordship, page 23 lordship. Page 23 lordship. Advertisement lordship, assistant professor in political science, 1 post reserved for SC lordship. Here the post, total number of posts is 1 lordship. And our specific stand in our affidavit is that lordship. In paragraph 9 and 10 in our affidavit, we have stated lordship. Yes. Paragraph 9 and 10 lordship. Paragraph 9 and 10 lordship. Of our affidavit. Affidavit filed by lordship Dharmakanto Mili, Director of Higher Education lordship. Respondent number 2 lordship.
Yeah.
Lordship. Paragraph 9 and 10 lordship. That the deponent begs to state that there is no provisions for making any panel or waiting list for selection and appointment of any post, including the post of assistant professor under the Assam College Employees Provincialization Act 2005, Assam College Employees Provincialization Rules 2010, Office Memorandum and Guidelines issued for time to time for selection of assistant professor of a provincialized college in Assam. As there is no rule requiring for preparation of a panel list, waiting list for selection and appointment of assistant professor in a provincialized college, if the recommended candidate does not join or if the recommendation and proposal is rejected by the directorate, it is duty of the authority of the concerned college to re-advertise the said post. Then Lordship, paragraph 10, that the deponent begs to state that for administrative approval, appointment, financial liabilities in respect to appointment for any post under the Government of Assam, the provisions of Assam Fiscal Responsibility and Budget Management Act, FRBM Act 2005 are strictly followed. In the FRBM Act 2005 also, there is no provision for making a panel or waiting list for selection of appointment of candidate. These are the basic stance, Lordship, taken by the government regarding this, Lordship. Now, Lordship, what the FRBM Act says, Lordship. You want the FRBM from Kodak here? FRBM, Lordship, already one copy is there before, Lordship.
Yes.
Here, Lordship, 7(1)(a). 7(1)(a), Lordship. Section 7(1)(a), Lordship. 7(1)(a). The state government or the appointing authorities under it shall give appointments only against the sanctioned post which is vacant and in accordance with the laid down rules, procedure and orders. Here the rule is, Lordship, 2010 rules, Lordship. Then, Lordship, Z. Z, Lordship, notwithstanding any other provisions contained in any act or rules, the select list prepared for the first appointment to vacant sanctioned post shall contain names equal to the number of vacant posts, Lordship, notified at the time of calling for application for filling up the post, Lordship. Here the notified post is, Lordship, number 1. So, Lordship, the panel list should consist of one person's, Lordship, not beyond that, Lordship. Lordship. Then, Lordship, there is a panel provision in under section 8, Lordship. Section 8 is there, Lordship. Whoever violates any one or more of the provision of the select is section 7 shall commit an offense which shall be punishable with rigorous imprisonment for a time which may extend to 3 years, Lordship. The authority of higher education, Lordship, cannot violate any of the provisions stipulated in this particular act. There is a penal provision is there, Lordship. If the authority violate, Lordship, they will face the penal consequence also, Lordship. So, Lordship, there is a specific bar from the statute itself that, Lordship, panel list should consist of the equal number of vacant posts, Lordship, not beyond that, Lordship. My senior sir has pointed out, Lordship, in the Act of 1981, Lordship, there is a provisions for preparation of panel list, Lordship. That act is, Lordship, in page 693, Lordship.
Hmm.
693, Lordship. First paragraph itself, Lordship. Whereas it is expedient to amend the Assam Education Department sections selections rule 1981, regulating the method of selection of principals and teachers of the aided college, notified by so and so dated, the government Assam is pleased to making the following rules, Lordship. These rules is applicable, Lordship, in case of grants in 8 colleges, Lordship. The petitioner's college, Lordship, Sunari College is, Lordship, not within the ambit of this particular rules, Lordship. Because, Lordship, Sunari College was provincialized by the Act of 2005, Lordship. And in exercise of the power conferred under section 12 of Act of 2005, Lordship, the rule 2010 is enacted by the government. That particular rule 2010 is applicable here, Lordship. In 1981 rules, Lordship, there is a provisions for preparation of a three panel, Lordship. Because, Lordship, at the relevant point of time, there is no any statutory bar or no any statutory act is there, Lordship. After coming into force of, Lordship, 2005 FRBM Act, Lordship, there is a specific act enacted by the legislature with the intention that, Lordship, there should be a panel list consist of equal number of posts, Lordship. The particular FRBM Act is applicable in all the departments under the government of Assam, Lordship. So there is no point of time any specific provision is required to be enacted or inputted in other acts, Lordship, because the whole things is covered under the 2005 Act. So there is no any provisions for preparation of the panel list in the 2010 rules because there is a specific bar under the 2005 Act, Lordship. That particular act is applicable in all the departments. That is the main issue, Lordship, because there is no provision of the panel list. Now, I also, Lordship, submitted certain citation of the Honorable Apex Court. Already, Lordship, I have given, Lordship. And that particular citation, Lordship, I have given in respect of, Lordship, regarding preparation of the panel list, Lordship. I remind that particular citation. I have given the citation, Lordship, the Bihar State Electricity Board versus Suresh Prasad case, Lordship, 2004 to SCC 681, Lordship. It was given, Lordship. And then, Lordship, I have given another two judgment which was reported in Monopatra, Lordship. Just remind Monopatra, Lordship. One is, Lordship, Union of India versus Monopatra, Lordship. One is versus State of Uttar Pradesh versus Varunesh Kumar. Monu SC 15992022, Lordship. And another one is, Lordship, Monu SC 04932022, Lordship. We can play the Lordship. The relevant paragraph is, Lordship, mark. I can again give the relevant paragraph is, Lordship. Lordship. That in respect of, Lordship, preparation of panel list, Lordship. And another judgment in respect of, Lordship. Another judgment, Lordship, regarding in respect of, Lordship, notifications and rules, whether it can override the principles, override the statutory provision of the law, Lordship. That was the Employees State Insurance Corporation versus Union of India, Lordship. AIR 2022 SC 1017, Lordship. Regarding statutory provision, Lordship. That particular judgment was given, Lordship, in respect of page 27, where one letter was issued by that one director, Lordship, regarding third candidate that can be also considered. On the basis of that, Lordship, I have submitted this particular judgment where there is no any statutory provision. If the statutory provisions cannot be overridden by executive instruction, that particular judgment is there, Lordship. That is in respect of that angle, Lordship. And another one judgment, recent judgment of the Honorable Court, Supreme Court was also given, Lordship. The golden principles of law laid down by the Nazir Ahmed in Privy Council, Lordship, which was reiterated. That judgment is, Lordship, Union of India versus Mohinder Singh.
Yes.
Monu SC 091022, Lordship. Here, Lordship, the Honorable Apex Court decided the law laid down by the various judgment of the Honorable Apex Court by applying the golden principles of law framed by the Privy Council in Nazir Ahmed case, Lordship. That particular judgment was I have placed, Lordship. In respect of Lordship, where the law prescribed things to be done in a particular manner, following particular procedure, it shall be done in that same manner, following the provision of law without deviating from the prescribed procedure, Lordship. Here the law and rules is very clear, Lordship. We cannot act beyond that, Lordship. For that purpose, I have placed that particular judgment, Lordship. Here I am relying paragraph 14 onwards, Lordship. Regarding, Lordship, the director is not a rubber stamp, Lordship. Before according approval, Lordship, he have to examine the records. After that, he can pass the order. If governing body send one document or one resolution, we cannot act upon, Lordship. In that particular point, Lordship, I have placed the Honorable our High Court judgment. It's reported in 2017, 1 GLP 77, Lordship. Paragraph 11 and 12, I am relying, Lordship. And Lordships also.
Yeah.
Even Lordship also, time and again, Lordship also held that this kind of case is a key mission, sir. Even my Lord also yesterday disposed of two writ petition regarding similar issue. And earlier also, my Lord, one judgment we have given, Akram Indojit Sinha, that is in the file of Lordship's file. We have already given, Lordship. And my Lord may also, that in that particular point also, my Lord can look into the matter. Otherwise, merit part I have, Lordship, already submitted. If Lordship thinks that that particular judgment, that particular order of my Lord is squarely covered, because the act, the particular resolution is acted upon by a directorate, it is not attained finality till that, Lordship. Yesterday also, Lordship, 2 matters came before your 3 matters came. Lordship said dispose of 2 matters in the similar line. Well, this is my submission. My Lord may consider everything and pass a reasonable order, Lordship.
I am the college authority.
Let the college authority.
My lord, just 2 point is, I file affidavit, my lord, from the governing body principal, my lord. Principal filed this affidavit, my lord. And in this affidavit, page annexure page 58, my lord, where we are going to give the panel list. So I am going to buy page 58, my lord. This is the permission given by the Director Higher Education for advertisement the post. Since 2017, the post is vacant and entire student community is suffer, as well as the school authority also, by giving so many litigations. First, my lord, your lordship, page 58, the permission of advertise of the post of assistant professor. This is the specifically says that assistant professor, one post is vacant, reserved for ST, SC, and permission last line, my lord, now quote, why we are going to 3, the panelists, why we are going to give the panelists by the governing body selection committee, my lord. Last paragraph, my lord, if one would permit me. In the event of first candidate joining elsewhere or not offering to join, the appointing authority may go in for preparing select list up to candidate number 3 in the comparative statement and not beyond subject to the approval of the governing body. This is for avoiding successive re-advertise for the same post. This is the specifically mentioned that the director is the competent authority. He has given the permission. That's why we are going to issued the advertisement, and thereafter we advertise the post, page 60, and we have one post, and thereafter page 61 in our affidavit, 3 candidates were selected on the basis of the merit. One, Miss Nilaksi Das, CL number 1, CL number 2, Debo Narayan Hazarika, and CL number 3, Dr. Swarnajuti Das.
Yeah. Lordship, one pattern matters. Obliged.
Three panel list was issued. All the selected committee signature is there, my lord. And thereafter, first candidate, Srimati Nilaksi Das, she filed an application before the principal regarding inability to join the assistant professor of political science as a reserve post. And due to inability to join, we have also written letter to the Nilaksi Das, first candidate. And she is not joining, and thereby we have give a proposal to the second candidate. And second candidate, Narayan Hazarika, already proposal was sent to the director, and director, along with the resolution number 1, page 66, 65, your honorable court may be pleased to see, page 65, annexure F. This is the, my lord, with reference to the subject side, I would like to state that the selected candidate for the post of assistant professor in the Department Political Science, Debo Narayan Hazarika, has been working as a postgraduate teacher in a so-and-so school. He has not submitted NOC, hence the proposal submitted by you has been rejected. But they did not say the one post for one candidate, you cannot send the proposal again. And thereafter, what happened, my lord? Governing body has a given resolution, and before that, the second selected persons came before the honorable court. Honorable court, my lord, might order dated. My lord, please may kindly see the order on page 40 of the writ petition. At least at that stage, the director filed an affidavit, or they did not say anything. Now from 17 onwards, all student community as well as college authorities suffer due to non-appointment. The specific, that's the main post, but there is a major course is there, but they did not do it. Madam, please may kindly see page 40. What honorable court say, my lord? Heard Mr. B. Gogoi is also there, and B. Gogoi Learned Council for the petition also heard K. Gogoi Learned Standing Council, so and so. In the selection for the post, it specifically mentioned that we have selected 3 candidates in panel list. In selection for the post of assistant professor in political science in Sonai College, Soraido, the petitioner along with respondent number 6 had participated. In the selection process, petitioner having secured so-and-so, place serial number 2, whereas respondent number 6 having secured so-and-so was placed as serial number 3. Later on, so-and-so, the first candidate on merit, Nilaksi Das, had refused to offer the appointment, and consequently, petitioner became the first selected candidate on merit. However, the respondent authority contemplating to appoint the respondent was 6, and against such grievances, writ petition had been filed. Mr. K. Gogoi, Learned Standing Council for Higher Education Department states that the petitioner had not filed her application through proper channel, and therefore the authority had refused the appointment petition in respect of second candidate is concerned. However, as pointed out by Mr. Gogoi, such requirement was not provided in advertisement. Therefore, the respondent cannot insist upon the same after selection process because of he has not given NOC, thereby showing this. In view of the above being prima facie satisfied and also considering the balance of convenience, irreparable loss petitioner may suffer, it is provided that the respondent nor any other candidate shall not be appointed to the post assistant for political science until further order. This order was specifically given. The stay order was given. Thereafter, my lord, this order was, this death writ petition was withdrawn, page 42. The interim order is vacated. Please may kindly see, page 42. Yes. On 11/3/2022, Sri B. Gogoi Learned Counsel for the petitioner submits that due to certain new development which has kept take place after filing of the writ petition, you would not like to pursue the present writ petition accordingly same stand closed as not raised. Consequently, interim order pass earlier stand vacated. It is made clear that on closure of the writ petition and vacation of the interim order, the college authority may go ahead in according with law. My lord, whole burden is given to us. Honorable Court, you proceed the matter, college authority may go, and thereafter, my lord, from authorities concerned, director also, they did not say anything, that you have issued a press advertisement. So thereby, we issued a governing body resolution was made, and on the basis of governing body page 66 in my affidavit, in our affidavit, and we resolution was by resolution dated 8/1/2018. Since the first candidate has refused to join and the proposal second candidate is rejected by the DSC, non-submission of NOC, the meeting anonymously resolved to appoint named the third candidate, Swaranjyoti Das, the post of professor, because so and so for a program. That this letter was given forwarding on 24/8/2018, my lord. So this may kindly see page 67. This is the proposal for approval of appointment of political science. With reference to the subject cited above, I have submitted here with the resolution governing body Sonari College held on 8/1/2018 for appointment assistant professor against retirement Sri Ganesh Borua in the Department of Political Science for your approval. It is to be mentioned that the panel select list candidate Mrs. Lilaki Das and first candidate refused to join. The copy of a refusal letter attached. Further, proposal second candidate Debonarayan Hazarika was rejected by the DAC due to non-submission of the NOC, by letter dated so and so. In view of the governing body resolved to send the name, the third candidate is Swaranjyoti Das for approval the post of assistant professor, Department of Political Science, as per letter number so and so. While this letter was issued 24/1/2018, my lord. But as per my lord rule, my lord, the director have only the power only one, given the only 30 days. Either reject, either approval. But till today, they did not give any approval. Either reject it or either in approval. But till today, whole governing body, all college authority as well as student community is suffering. So my humble respectful submission before Lordship, Honorable Court decide the matter, and I think either approval or as my lord immediately due to suffering from the student committee. This is my humble submission. We have regarding is in respect of a one post is concerned in direct as per instruction by the college authority from 2020 they circulated regarding the one post is one concerned direct. This is my humble. At that point of time, director has directly says that you have a panel list. So we have given the panel list. So there is no any violation. This is my submission from the college authority.
May please the Lordship. The whole case stands with a very narrow compass. But then the respondent government is trying to twist it in such a way so that there is a big, larger question to be decided, and therefore they are referring to so many judgments, so many things. But I'll, in reply, without repeating the earlier facts I have already placed before your Lordship, my responsible submission would be: they have urged that this petition itself is premature. My responsible submission: it is not, it cannot be, because I approached this honorable court for a direction to the authority that my appointment should be approved and appointment letter should be issued. The authority failed to act as per the dictum of law. Lordship has read it earlier under Rule 7. rules have been placed. Rule 7, the director shall communicate his order within 30 days. This is the dictum of law. My proposal was forwarded by the college authority way back in 2018 first. And then it was reiterated in March 2022. March 2022. By April, you have to have decided the case, this set of argument. I approached this court in June, last part of June. After 3 months, therefore, even after that renewal of the proposal in 2022 March, I approached after 3 months there. Therefore, when direction was that within 30 days you communicate, that was not done. Therefore, he failed to discharge the statutory duty, and therefore this honorable court has every authority to call upon him and direct him to discharge his legal duty. Then, next question is the question of preparing a panel list or a wait list. This decision 2004 2 SCC, Bihar SCB, Lordship will find these facts are quite different. Panel list was prepared in that case. Question was whether there is a select wait list should be there or not. A wait list was also there. When none from that panel reported for duties, then claim was made by the waitlisted candidate that we should be appointed. The apex court said, no, you cannot, because wait list was not to be acted upon. There is no provision for the wait list in the rules. Therefore, we cannot direct that they should be appointed. In that context, the court has held so. It is basically with respect to wait list candidate. Here is no question of wait list, only one panel. I will come to it. Therefore, the other decision also that same thing, 33 number of candidates in that Manupatra case, Malad, they have referred to. 33 candidates in the panel, wait list was not to be prepared, but then wait list candidate came and the wait list was insisted upon. Therefore, in that context, said that wait list cannot be acted upon. And in the Nazir Ahmed case, the apex court said that golden principle that either you do as per the prescribed procedure or don't do at all. We have no dispute to that. That is what we are saying. But the question is, when the rules are silent regarding preparation of any panel list or any wait list, then how to construe the rules? Something which is not there in the rule cannot be construed to be, cannot be read. If the rules are silent regarding preparation of a wait list, then there is no question of wait list. Here is where the question of wait list doesn't arise here. Whether a select list can be prepared, question is this. Whether a select list can be prepared. When the rules say that the governing body shall conduct the selection process and recommend to the director who shall issue orders of appointment. Obviously, when the selection process takes place, the legal fallout of the process is that there will be a select list. Some persons who were selected, their name will be there. Therefore, where it has been said, is it said in the rules that there cannot be a select list after selection process is complete? No. As a matter of corollary, it follows that when a process of selection is taken place, then obviously a result has to be published who have become successful in the process. So select list must be prepared. Question of wait list, there must be a specific provision. And here, wait list is not there, not prepared. Then, whether the panel was forwarded as such to the director appointing authority to make appointment. It should not be confused that the college authority forwarded only one name at a time. Can you mark the difference, my lord? It is not the case that the college authority prepared a panel of 3 persons and forwarded the entire list of 3 persons, the panel, to the director, asking him to make any appointment from that panel. That is not permissible. That is not permissible. You have to forward only one name. If we give a purposive construction to rules to section 7, subsection 7 of that FRBM Act. Let us take it for the time being. Let us take it. Whether if they want to insist that, because now they claim that FRBM Act comes into, it provides only for one post, one selection against one post. 1:1. For the time being, let us take it. If we even go by that, Lordship will find here the authority, the recommending authority, the selection authority, that is the college authority, did not forward the panel as such to the director for appointment. They forwarded only one name at a time. When the first one refused, then the authority forwarded this second one, second name. Panel is with them only. Selection was made and they have kept the select panel with them. And then they forwarded the second name. There was no requirement of approval of the panel. Lordship will kindly note. There is no requirement of the approval of the panel by the director. Director is to appoint only one person who will be recommended by the college authority by resolution of the governing body for appointment. That is the position here. So one should not confuse it. Things are apparently clear. Therefore, when the first one of the panel refused, second one proposal was forwarded, one name was forwarded to the college authority, the director. Director took the objection that no, you did not submit no objection, therefore you cannot be appointed. That time he approached this honorable court. In this court also, they did not take up this point that his name could not have been forwarded, or that FRBM Act comes into play, or that no objection is a must because we incorporated that provision in the advertisement that one who is already employed, he must produce NOC if he is at all selected. That was not there. That is why Lordship has read this order of our court, earlier order. My learned friend has placed it on behalf of respondent number 3. This court said that NOC we cannot insist because it was not a condition of the advertisement. And they didn't raise any other objections. Therefore, initially stay order was granted. And then when he did withdraw the petition, did not press it, court vacated and directed that as in accordance with law, the college authority shall proceed. There also, nothing has been said, or they didn't urge the court that now they will have to go for fresh advertisement. That was not the plea taken by the director. That was not the plea taken by the director. Therefore, at that instance, when 1 and 2, they themselves are withdrawn. I will put it like this. 1 and 2, these two candidates, they themselves did withdraw from the race. Said, no, we are not coming. Then only one remains in the panel. One remains with the college authority. And college authority decided that the candidate who was selected, the other two having withdrawn already out of 3, his name was, her name was recommended with a resolution that she should be appointed. And one name came before the authority. Where is the panel? Where is the panel? How can the director now say that, well, panel is there? How can I act upon the panel? Because kindly see that portion also, the appointing authority is the FRBM. FRBM appointing authority was directed. I will come to it that it is not applicable even then, to answer their submissions, objections, here, Lordship will see FRBM page 9, section 7. What it says, Lordship might have taken note of earlier, I submitted this point. Measures to ensure fiscal discipline. It is regarding fiscal discipline. Lordship got it, my lord? Yeah. 1, with a view to ensure timely discharge of current liabilities, especially payment of salaries to the employees. See, my lord, purpose. With a view to ensure timely discharge of current liabilities, especially payment of salaries to the employees. A, the state government or the appointing authorities under it shall give appointments only against a sanctioned post which is vacant and in accordance with the laid down rules, procedures and orders. Whatever rules, procedure, orders are there, as per that, they will give appointment against specific vacancies. Because what happened that time, my lord, Lordship may recollect, many appointments were made in different departments by the authorities without a vacancy. Therefore, a lot of chaotic situation arose and many cases were filed here. Those were, some of them are still pending. That is the situation. And then to see, next page, my lord, G, Lordship will come to G, this A, B, C, D explanations, then B, C, D, E, F, G. My learned friend was harping on this particular provision. Notwithstanding any other provision contained in any act or rules, the select list prepared for the fresh appointments to vacant sanctioned posts shall contain names equal to the number of vacant posts notified at the time of calling for applications for filling up the post. So it says that when you prepare appointing authority, when you prepare government, when you prepare, then you prepare one for one post. Select list, that is one against one post you should select. To avoid the situation so that no one else can be appointed. That means there cannot be two appointments against one post. That is the purpose. That is why this honorable court in a division bench has already held that this purpose is different and it will not apply in case of such selection when rules are already there. Therefore, my lord, my responsible submission is, even if we take it, this is strictly to be followed by the appointing authority. I am not the appointing, college authority is not the appointing. Appointing authority is the director. Director got only one name at a time. He got second person's name. He took the point of NOC. He did withdraw from the race, gone. Then only one name came to him, director again, that is me. No panel has come to him. So he cannot construe that there is a panel and I am forbidden from acting on the panel. I cannot choose someone from the panel of 3. It was not the case. Therefore, in my responsible submission, this provision of law has no application in our case. More particularly, it cannot be applied. It cannot be applied because our selection was held in, kindly see, my lord, 2017. 2017, our selection advertisement was issued. This was issued on 4/9/2017. I will come to it how the government has dealt with the entire matter. 4/9/2017, page 28. Select list was prepared. Selection was held, that is 28, page 28, Mala. This is the type copy. Second page 29 is the original copy, photocopy. Here, out of these 1, 2, 3, 4, 5, 6 candidates, 3 candidates has been selected on merit. 1, 2, 3, like this. Remarks column, the position has been mentioned. This was in 17, and this was done pursuant to the direction of the director, where the director himself said that you can go for a panel of 3 when you make selection. Kindly see at page 27, page 27. Lordship has noted it, my lord. 27, last but one para. In the event of first candidate joining elsewhere or not offering to join, the appointing authority may go in for preparing select list up to candidate number 3 in the comparative statement and not beyond, subject to approval of the governing body. Subject to approval of the governing body. Governing body approved it. So you can make a panel of 3 subject to approval of the governing body, so that you need not have to go for repeated advertising. This was pursuant to the order of the director. The director's order, Lordship has seen the signature of the director down below, page 27. Accordingly, it was done. So approval of the authority was there. Was there any notification during that time saying specifically that you cannot prepare a panel of selected candidates more than one, containing more than one person? Was there anything? I have searched to make the whole thing clear. I have searched, and it is found that during that time there was no such notification. Rather, this was the guideline issued by the authority that you can prepare 3. It was not there. In thereafter, what I find in 2020, there was a notification. I will place it. Let me copy there. These notifications ought to have been placed by the government side to make the things clear. They have not come up clean with all these notifications. That's how I had to charge out, and I could look at these notifications for a clear understanding, so that there cannot be confusion. This notification is 4th February 2020. It is a notification by the Higher Education Department. Lordship will see. The government of Assam in Higher Education Department is pleased to allow, kindly see, is pleased to allow to give approval to the governing body of the provincialized colleges of Assam for filling up of vacant sanctioned post of assistant professor of provincialized colleges of Assam after satisfying the following terms and conditions. So this is, by this notification, approval was given to the governing bodies of the colleges for making selection for appointment of assistant professors. Here, number 1, 2, 3, all these are there, my lord. Approval for the roster, 38 years, upper age limit, fulfillment of educational qualification, reference date of acquiring qualification. 5th, governing body of the college should ascertain that the posts are not sub judice personal posts. 6th, the governing body of the college should give an undertaking that the concerned sanctioned post has not been previously filled up or lying vacant. Then the governing body of the college should ensure that the post shall be filled with strict compliance with provisions of FRBM Act 2005, existing Reservation Act and rulings of the Honorable Supreme Court, as well as order of the Honorable High Court, and in accordance with the service rules and due procedures established by law, and also filling up the vacant post against sanctioned vacant post only. Here is we find a reference to FRBM Act 2005. It says the governing body of the college should ensure that the post shall be filled with strict compliance with the provisions of the FRBM Act. That means, basically, as I pointed out, if there is a vacancy, that should be filled up, nothing more. Existing Reservation Act, rulings of the Supreme Court, Honorable High Court, and in accordance with the service rules and due procedure established by law. Service rules has been referred to. At best, my lord, if we construe, this is also not applicable, but even if we construe that this here is a reference to FRBM Act, this provision is applicable. This came only in 4th February 2020. Election was held in 17. So this is not, it cannot be applied retrospectively to my case. This is not applicable. This is not applicable. This is notification. Again, it has undergone changes. Thereafter, detailed procedure, office memorandum has been issued by the commissioner and secretary. So it stood obligated, obliterated. 20 চনৰ পিছত কোনখন ওলাল 22 তাৰপিছত 20 কেতিয়া
Senior counsel.
সেইখন দিয়া
There's a reference today, no?
Yes, my lord, reference is there. Doctor will have to write. Only I will have to place these 3 notifications so that the picture will be clear.
Day after tomorrow?
Day after tomorrow.
DK Das.
DK Das.
Higher education. And Mr. N. Bora.
Lordship may rule that they have completed. I am only to complete so that there cannot be any repetition further.
Second. This is only for your.
Yes, yes. I'll place these notifications and then sum up.
With your lordship's leave, I'd like to mention item 20, which was a matter which was fixed for consideration of the interim. Since the time constraint is there, I pray that this matter be taken up on 9th.
There is no prayer, no direction in the order that it will be considered. It's subject to outcome of the case.
No,
I have
no,
entered
no,
appearance for the.
No, the order is there, lordship.
My friend is appearing for the president. My lord will give us 2 weeks time so that we can find, and she's under suspension.
My lord, the order is there in interim. Possibly my learned friend has not seen the order. It's for the interim.
The first order, my lord.
On the 9th, lordship, it's a Thursday.
My lord, 19/1/2023 order. It says it is subject to the outcome of the case.
There he's reading the last part. The first part says. Notice.
My
on
lord
the
will have
interim.
the matter after 2 weeks and I'll file my affidavit in the meantime.
Notice on.
And she is
interim
under
there.
suspension.
In derogation of the rules, I was removed from secretaryship. Issue notice on interim prayer returnable on 28th. So I made a prayer for interim. And the court says that, okay, on the first day, we'll give it provisional, but on 28th, we'll consider your interest.
And
So lordship, on next day, because what has happened, connected, after coming to the court, I was placed under suspension. That is before another bench. So I went.
This order, my lord, in this case, until and unless the suspension order goes, she cannot come back to the college and hold the post.
No, my lord.
So, my lord, there is no rush now.
Okay, but you can ask. You are appearing for first time.
I am appearing for the first time.
So am I, my lord.
Mr. UK Nair.
I'm appearing for respondent number 3. 3.
Senior counsel assisted by Mr.
No, I'm.
M. Sharma.
M. Sharma.
S. Sharma.
No, no.
M.
For respond number 3.
3, my lord.
And MS.
S. Sharma, Sumitra Sharma.
S. Sharma.
Correspondent number 5.
And praise for. How much time you want?
My lord will give me 15 days time. I'll file my affidavit in the
2 weeks, my lord.
2 weeks.
No, I have some objections. my lord.
What objection?
No, lordship, if they have asked for 15 days since the interim or consideration, I can always ask for 10 days. A balance, lordship will take the call.
There's no earth shattering evidence.
Stop. Please, the matter again on. Today is what, 28?
Today is.
Yes,
20.
lordship.
Today is first, no?
Today is first.
28.
28.
28, sorry.
See, the next week, 4 days. is a
Yes,
holiday.
it's a holiday.
That's right.
So we can't help it.
Yes, lordship may fix it on 16, lordship.
16th, my lord, I have a
Then-
urgent prior personal commitment, my lord.
Fifth.
15th, 16th, and the Monday, my lord, following.
Let you,
Any date before that or after?
yes, 14 will be convenient.
14.
Obliged, lordship.
Much obliged.
Obliged.
2 weeks by.
ঠিক আছে।